Beg your pardon to make one mention. My lords. It's a fresh matter.
My lord, this is the IL matter, my lord. Yesterday I
Beg your
had
pardon to
given
make one
memo.
mention. It's a fresh matter.
My lord, this is the IL matter, my lord. Yesterday I had
Item number 1.
You find your affidavit?
It's a fresh matter.
My lord, this is the IL matter, my lord. Yesterday I had
Item number 1.
You find your affidavit?
It's a fresh matter.
But however, I have a small query, my lord. My lord,
What however?
there are other factual disputes which I have
Item number
mentioned.
1.
I only beg your liberty to, Lord, I only pray that I will, if there is cause of action still survives, then I will approach the appropriate authority. My lord, that liberty I seek, my lord. There are other factual disputes because I have specifically mentioned about the sexual disputes, my lord. That is there.
Don't enter the
Lord, I only pray that I will, if there is cause of action still survives, then I will approach the appropriate authority. My lord, that liberty I seek, my lord. There are other factual disputes because I have specifically mentioned about the sexual disputes, my lord. That is there.
Don't enter the
Lord, I only pray that I will, if there is cause of action still survives, then I will approach the appropriate authority.
Present petitioners who have been working as tutors in different private nursing colleges, they have preferred this writ petition in the nature of public interest litigation, challenging the inaction of the state government in not issuing any advertisement
Who have been
for
working
appointment
as
of the post of tutors.
in different private
Because
nursing
what
colleges.
they are doing, they have framed a rule
preferred this
at
writ
last
petition
in
in the nature of
2020,
public
that is
interest
Annexure
litigation,
4. On the
challenging the
basis of
inaction
though
of
the
the
rule
state
was
government.
framed, but in
Only the
not
tutors
issuing
and the
any
government
advertisement,
Who have been
yes,
working
they are
appointment of the
without
post of
issuing any
tutors in
advertisement,
different
they are
private
taking
nursing
what
colleges.
the teachers
They have
who are
framed a
working
rule
in
at
government
last in
nursing colleges.
2020, that is
But
Annexure 4.
whereas we have been
Challenging the inaction
deprived
of the state
from
government.
participating in the selection
But
process,
not
since
issuing
no advertisement has been issued.
Who have been
We are
working
not getting an
without
opportunity
issuing
any advertisement to apply
They are
or to
taking
participate.
what they
The
are doing.
teachers
They have
who are
framed a
working
rule
in
at
government
last in
nursing colleges.
2020, that is
But
Annexure 4.
whereas we have been
Basis of
deprived,
though the rule was
they
participating
are
in the
filling
selection
up.
process, since no
They
advertisement
are
has been
filling up,
issued.
but
We
without
are not
issuing any
getting an
advertisement. The last advertisement was issued in since then no advertisement is issued, but in each and every year they are filling up the post. They are filling up, my lord. They are filling up, but without issuing any advertisement. The last advertisement was issued in since then no advertisement is issued, but in each and every year they are filling up the post. They are filling up, my lord. They are filling up, but they are not making any advertisement. For that reason, to participate for direct recruitment is issued. My grievance is that every year they are filling up the post. If they are filling up, my lord, they are filling up, but they are not making any advertisement. For that reason, a person will be appointed as tutor, then the promotional avenue of a tutor is assistant professor and etc. etc. Every year they are filling up the post. If they are filling up, my lord, they are filling up, but they are not making any. That is my grievance. If they will issue an advertisement, then we can get scope to participate in the avenue of a tutor is assistant professor and etc. etc. They are filling up the post.
Applications that they have started.
Yes, that is my grievance. If they will issue an advertisement, then we can get scope to participate in the avenue of a tutor is assistant professor and etc. etc. They are filling up the post.
They are challenging the rule also. At page 16, their
That is
ground
my
number 10,
grievance. If
they are
they will
challenging
issue
the
an
rule also.
advertisement, then we can get scope to
Your
participate. Your Lordship may kindly peruse page 12. Page 12, Your Lordship may kindly peruse. Page 12, paragraph 4.11.
They are challenging the rule also. At page 16, their
That
ground
is my
number 10,
grievance.
they are
Yes,
challenging the rule also.
What you have said, sir.
Here I have stated that they are without issuing any notification for selection for the post of tutor, they have effective steps to observe the candidates who are engaged in government institutions only.
At page 16, their ground number 10, they are
Yes,
challenging the rule
my here I have stated that they are without issuing any notification for selection for the post of obliged.
My lord, item number 3, my lord. I am for the petitioner. Read petitioners are villagers of local village. They have filed a annexure 3 before the Tahsil. Video Satyavadi for disposal of. My lord,
Obliged.
You are not a local
my lord,
villager.
item number 3, my lord. I am local villager. Petitioner. Read
You
petitioners
say
are
read petitioner
villagers
and the local villagers.
local
That's why
village.
I asked
They
this
have
question.
filed a annexure 3 before the
My lord,
Tahsil.
their
Video
village from
Satyavadi
Dangura.
from Dangura, Satyavadi, under Satyavadi
You
block.
are not a local
My lord,
villager.
item number 3, village of Dangura, Satyavadi block.
You say read
They have
petitioner
filed a
and the local Angarwadi center.
They have filed a annexure 3 before the
My lord,
Tahsil.
their
Anganwadi
village
center
from
is going to be
Dangura.
constructed, but the villagers have filed a grievance petition before the BDO. Village number 2 to construct their nearby
What is
land
Angarwadi
of
center?
village. Though the children's minor people, Anganwadi center kids will go to the Anganwadi center for villagers for better safety for the BDO. Children, it should be constructed before nearby land
It
of
is from your village.
though the children's minor Anganwadi center kids will go to the Anganwadi center for villagers for better safety for the minor children.
200
It
meter.
should be constructed minor nearby
200 meters from your village.
though the children's
Far
minor
from place.
minor that is near inside the village. They should be constructed inside the village.
Then I believe that every Angarwadi center should be constructed within the village.
Minor nearby
200 meters
I have
from
prayed for
village has a, every village has a aspiration to have a Angarwadi center within the village. So every village must be catered with I believe that every Angarwadi center should be constructed within the village. So there is no question of any block. There is no question of any village has a, every village has a aspiration to have a Angarwadi center within the village. So every village must be catered with I believe that every Angarwadi center should be constructed within the village. So there is no question of any block. There is no question of any village has a, every village must be catered with I believe that every Angarwadi center should be constructed within the village. So there is no question of any block. There is no question of any village has a, every village must be catered with I believe that every Angarwadi center should be constructed within the village. So there is no question of any block. There is no question of any village has a, every village must be catered with I believe that every Angarwadi center should be constructed within the village. So there is no question of any block. There is no question of any village has a, every village must be catered with I believe that every Angarwadi center should be constructed within the village. So there is no question of any block. There is no question of any village has a, every village must be ca every village has a aspiration to have an another indicator within the village. So every village must be catered.
I
I believe that
have filed my grievance petition
correct within the
to
village. There is
BDO.
no question of any block. There is no question of any village has a every village has a aspiration.
250
to have
meter
a
is not a
within the
quite a distant
So
place.
every village
You
must
yourself have said in your petition.
I filed my grievance petition to BDO.
The earlier accused is Honorable Pothak.
Sir, even we cross from the old building to a new building, we have to cross one and a half to quite a distant place. You yourself have said in your petition.
I filed my grievance petition.
So,
Small children.
The
That
earlier
is
accused is
I
Honorable Pothak.
understand, sir. The small children are very energetic. New building, we have to cross one and a half to and it is spared in a very nearby location. It's not that far flung place. I can understand that they have to go for 2-3 kilometers on walk, and then that's appreciable that it can't be because the children's convenience is also to be taken. 200 meters is nothing, sir. That they have to go for 2-3 kilometers
BDO may be directed to consider
on walk, and then
and dispose of.
I have a very strong reservation on consideration of representation. If you have a right, you have a right. I will decide. Unnecessarily putting this particular question open, I am the last person to encourage consideration of representation. If you have a right, you have a right. I will decide. Unnecessarily putting this particular question open, I am the last person to encourage consideration of representation. The government, they will find a suitability where if you have a right, so that you have a right. The person of the nearby villages, they will get the access there. Putting this particular question open, I am the last person to encourage.
The writ petition also shows that it is being constructed in an adjacent village.
And which is not far off because they are
Not far.
admitted.
Yes,
It is a 1/4 kilometer. That will bring us to 250 meters.
And again, Lordship will find at page 19 of the writ petition, the earlier this petitioner approached this honorable court and judicial order was passed that he will ventilate his grievance for the authority. He has not done it.
That will bring us to 250 meters.
And again,
So that is why he
Lordship
has
will
come.
find at page
The right
19
is
of the
created,
petition,
fructified by virtue of an earlier order to raise a grievance.
and
He has raised the grievance by way of representation.
No, my lord.
You have not taken
No,
that is annexure 3 is
Lordship kindly have a glance. This order was passed on 5/4/2025 and his representation in 21/3/2025. Thereafter, he has not approved. And
he has raised the grievance by way of representation. You have not taken that is where is that order?
At page 19, Lordship kindly have a glance. This order was passed on 5/4/2025 and his representation in 21/3/2025. Thereafter, he has not approved. And
He has raised the grievance by way of representation. You have not taken that is where is that order?
at page 19, Lordship kindly have a glance. This order was passed on 5/4/2025 and his representation in 21/3/2025. Thereafter, he has not approved. And
He has raised the grievance by way of representation. You have not taken that is where is that order?
at page 19, Lordship kindly have a glance. This order was passed on 5/4/2025 and his representation in 21/3/2025.
Raising the
Thereafter, he has
critical
not
issue.
approved. And minor mineral.
Minor mineral.
Sand Sairat, minor. Sairat borrowed from
This coinage of the word, that's why I wanted to.
no.
No.
I think that has been borrowed from that Bengal Tenancy Act.
Sairat is
Minor mineral.
minor mineral.
Sand
Sairati,
Sairat,
right. They call it a Sairati, right.
Sairat. In that context only this has been borrowed here.
Mr. Kaur will be able to know.
That the British, I think that has been here also in that Odisha Tenancy Act. The Sairat was allotted to me through auction process. I become successful. It was for 5 years granted to me. Then my auction, that the British, I think that has been here also in that 22 months. In year 2022, the Sairat was allotted to me through auction 27. This is an auction process. What happened? That was done by Tahsildar, the Revenue Authority. But in the course of time, that has been transferred to mining office. Then what happened? The Tahsildar required that all these I form issued, 27, the transit forms that is being issued, that should be surrendered to Tahsildar. I surrendered it. Then Tahsildar sent the record to the mining officer. Mining officer is required to give me a permission to operate the quarry. Then mining officer wrote me a letter that you prepare that mining planning which you have got. I surrendered it. I have dealt with that mining officer. Mining officer is required to give me a permission to operate the quarry. Then mining officer wrote me a letter that you prepare that mining planning which you have got. I have all this should continue. Continue as such. Then documents and records. Wrote me a letter that you prepare that mining planning. The surrender in the sense when not surrender, it is a transfer. I have the transfer from Tahsil office to my lords, the continue as such. That is their internal. But thereafter what happened? The mines of Sharma kind of last annexure 7 is 53. The surrender in the sense when not surrender, 53 mines transfer. I have the transfer from the mines of mines continue as such. That is their wrote me a letter. But thereafter what happened? To submit a revised mine planning, modified mine planning confirming there is a dispute concerning coordination points. Let us know that the coordination point differs means when coordinate so that coordinate manners are the x-axis and y-axis. This is ordinate modified mine planning confirming there is a dispute concerning suppose manner coordinate 6 miners. Then this side of the shifted to some other different place. So they require to file a trace modified coordinate plan so that the source can be operated smoothly. We submitted it. That must once mines planning, I submitted the coordinate mine planning. They verify and give it to me. I am unable to operate. That is what I have come before the Honorable High Court. 2 Sairas I got my one Sairas I have come before the Honorable Court. Submitted. The Honorable Court passed an order required manner comment to file the response. In this case, also the same verify and give it to me. They are not what happened. They have not given me permission. I have not operated the quarry. Now they are raising the demand. So far that demand is concerned. In that case also they raise the demand. In this case, in this case also the same verify and give it to me. They are not what happened. They have not given me permission. I have not operated the quarry. Now they are raising the demand. So far that demand is concerned. In that case also they raise the demand. In this case, in this case also the same verify and give it to me. They are not what happened. Some knowledge on that revenue law. Here in this case, Moja plan is there. Of course, that more gets variation because of the now development of new technology manners that aerial measurement and all these things. That has not been taken up here. That old Moja plans that was done on measurement, chainage measurement system. Cadastral measurement system there. So generally doesn't it varies. So that is 5% variation is permission. But my humble condition is that real measurement and all these things that has not been taken up here. And so that's our old seabed that was done on measurement, chainage measurement system. Cadastral measurement system. Cadastral so far Almar is concerned a part has been done, a part has not been done. Permission. But anyway, my humble condition is that real measurement and that was during that was here. So that's my humble condition that during 1915 that starts here in this case cadastral measurement. Cadastral so far HON'BLE is concerned, a part has been done. Cadastral minors, it was it starts from 1889 on the order of Bengal settlement. So far Bhadrav, a part of Puri. But thereafter 1960 is at Odisha Tenancy and Tubing. Thereafter, so far Bengal presidency is concerned, that minors it relates to minors from starting from Baleshwar till Puri. It ends at thereafter means Ganjam. Ganjam is under Puri. That was under Madras presidency. Another part minors starting from Balangir, Sonpur and onward, that is under Central Province. So Odisha is a combination of the three. My humble contention is that here in this case, thereafter means particular area is also part of that is Madras presidency. A part of that under Madras presidency. But anyway, that is not there. Madras once the state has been formed. So Odisha is a combination of 37. My humble contention is that here in this case, thereafter means particular area. Ask me, yes, that is Madras presidency. A part of that under Madras presidency. But anyway, that is not there. Madras once not from the only state has been formed. Yes, Odisha is a combination of 37. My humble contention is that here in this case, thereafter means particular area. Ask me, yes, ma'am, exactly, my so that not from the only yes, my pleasure, my pleasure, my. It's my pleasure, ma'am. Ask me, yes, ma'am. But fact is, ma'am, I should tell, I will tell my view about that. Not from the only yes, my pleasure, my.
Boundary, the schedule.
Yes.
Then
That exactly, actually, what has happened, my lords?
of giving the coordinates and all everything by the mining of.
Well, so what has happened, my lords?
My lord,
I will point out that. Why it is happening, my lords? I also inquired about that. I understood the thing is that mines officers, they are equipped with the very modern technologies. What Tahsil didn't have. It usually follows the chain system. That the chain, that Kadi system and chain system. But these people, they do have drone survey and all these things. That is what they resort to very specification. And they sometimes they review it. And they see, because minus what is happening, seabed, 4 acres of land. Out of that, I am giving, suppose minus 200 decimal, 300 decimals. They have to point out 300 decimal. Tahsildar went there through chainage system, measured it, made it, and this is the area. I started exploring. Then these people, they drone survey found that is corroborating the coordinate. That is what they required to submit a revised mining plan. I submitted their mining plan. I submitted, it's all right. You can resort to your technology. You have to ascertain this area. You have to identify in that area.
That I understood.
That exactly, my.
How can you, if the law or there is an interdict in operating the mine, then how can you saddle him with the liability?
my lord, liability,
You can't say both the bird in the hand and a two in a bush is yours.
Have it and then
after transition by operation of route, after defect in the mining plan was pointed out, my lord. He was asked to submit the mining plan.
I appreciate that
Well,
particular word which you used. Can he? I'm just, if you want to cancel, let him take a recourse to a law for cancellation of the mining. Raise this kind of a disputes and succumbing a particular the person to his dictate.
But the petitioner has responded to
That is
to the so cause.
What you suppose from these persons?
But
What do you suppose?
But he has responded to the so cause notice that is pending. Now, pending that response, my lord, he has a
notice.
Yes.
If it is a so cause notice, have you then whether he can permit you can permit him mining activities?
Mining activities have been closed for there are also other requirements, my lord. He wants.
Asking, can you charge for a royalty during that period where you have already prevented him from doing your mining activities?
But that I'll have to ascertain from the authorities. That I'll have
you
to
have
ascertain.
To give me 3-4 dates. First thing is the amendment. I think that has been 2020 or 22.
22. Well, 22,
23,
23.
Now thereafter, this the first letter, and that shows that you cannot operate mining. That's the demand for that. This is a concluded contract. What is the
23 for 23-24 and further. So that is the
when he was prevented.
He was prevented from.
I asked the date.
That the documents were transferred to him on 8/11/2023 by the Annexure 6.
And this demand was in respect of what period?
So that is for the period from.
Letter of demand is an annexure.
Annexure. That is minutes at Annexure 12.
12 or 9.
Annexure 9.
Annexure 15. That is the last notice.
Last notice.
So cause notice. That is at Annexure.
No, I just wanted. That is a notice.
Notice is at minor
hearing.
Yes.
I'm just. Where is the demand?
Demand minors. Demand is at minors annexure.
Proposals.
Minors at.
Demand of 1 2.
Minors kind of annexure 10.
Where is the letter dated 7/8?
Minors 7/8 annexure 10.
24-25. Surface rent of 24-25.
Minors.
56. 56 is 23-24. So you have been prevented from 2022.
23 minors that I was prevented from minors, that is from 8/11/23 minors I surrendered. I was prevented from October 23.
23. So up to October there is no difficulty.
No difficulty. I am bound to pay. I've already paid in advance. It should be adjusted.
Like instruction there.
We will stay. No further actions.
Well, here, if your lordship will see, there is no action taken as of now. Your
don't proceed any.
I will fail in my duty, my lordship. I will not bring it. Another side, their my lords have not stated this. You said that if the so cause is there, it is there in the so cause. My lords require the count. So in this case, my lords stay.
I understand, but this is a case which is
the order passed in the other case.
That is
shall fail by me to better unless, my lords, I bring it to the notice of honorable court, my lords. Both the case I may, a small prayer, my lords, both the case may be tagged off so that can be taken up at the address.
Tag it. When
Lordship, 2 weeks.
you have filed your affidavit there,
But
No.
that I have not.
there was already a direction.
Yes, no affidavit filed.
3rd July, was it
3rd
listed?
July.
No, it was
already-
not listed.
3rd July.
But it was not listed. I have not received the affidavit. No affidavit filed.
We are filing the. In the
This
meantime, we are
matter-
filing
this
both
is
the
ma-
cases.
Both the matters
Both
on
the matters.
Wednesday. Let us see why you will not file your affidavit. It was long back.
This matter, your lordship may
Both the-
grant
both
me
the
2
tag-
weeks because other
yes,
matter
tag-
that was not within my knowledge. Today.
Tag it
on the
and both be listed on Wednesday.
Obliged,
Present matter, your lordship may grant me 2 weeks time, so at least
Let
I.
us not like.
Item
5.
May I please, Your Honor? And here the petitioner has been granted, in the month of June 2021, the petitioner has been granted a mining lease for sand mining, and it is valid for a period of 5 years. And then
2022.
21, valid till 2026.
Yes.
My lord, may kindly turn to page 30.
Then
Annex
what
of-
happens? Then what happens?
Well, here, well, there is a restriction in the environmental clearance, that the environmental clearance was granted till November 2021. Thereafter, if the replenishment study report is not submitted, approved by the CI, not
Then you
submitted,
can't continue.
you can, so accordingly, I submitted the report that is yet to be accepted, and my mining is stopped since then. Now, my lord, in the meantime, while the situation to the departments were changed, now, my lord, at page Annexure 10 at page 54, my lord.
Yes.
This is the demand notice by the competent authority, that is mining officer. There is 2/2/2024. My lord, can say, according to the provision of Rule 32 of OMC Amendment Rules 2023, you are directed to deposit the following amount of dead rent, surplus and DMF, EMF, and other requisites for the second year and third year of lease are detailed below within 15 days. My lord, may kind go to next is column number 4. Demand as issued by Tahsildar Champa for the year 21-22. 4th column.
Yes.
Well, these are the total demanded amount. I have paid that amount.
That is the 10% of the loyalty.
Yes.
1,73,000. What?
No, my lord, can see the
DM. What?
heading is demand issued by the Tahsildar. First demand is royalty 17,35,000. Then surface rent 72. Dead rent.
Not 70. The 17,35,000.
Yes, 17,35,000 royalty amount.
Yes.
Then surface rent is 72 only. Dead rent 0.
0.
DMF 1,70,560.
Correct.
EMF is 86,780. Then TCS is 34,000. This is for first year, that is 21-22.
Yes.
Accordingly, I paid all those amounts. Now, my lord, may kind on to the next column. Paid by the lessee for the year 21.
So the whole amount. Then
21 paid. Then next, my lord, you can see second year of lease. May kind on to.
so 5,000 demand.
Yes, that I have paid. Under annexure 11, I paid all those amounts.
Yes.
Now, my lord, on the next document at page 67, annexure 14.
Yes.
This is also a demand notice issued by the mining officer for the 4th year.
Correct.
Hello, 24-25, my lord, vacancy only 2,537. Now, what happened? My lord, vacancy, the Tahsildar, who has no jurisdiction in the matter after 2022, well, he raised a demand of 24,47,000
Which?
under annexure B. For the second year of lease. Now in 2025, he is raising a demand of 24,47,263.
For the year 2022-23.
Yes, for the second year of lease. Well, mining operation is stopped, and this Tahsildar has no jurisdiction after 2022. Well, he raises a demand in 2025. Well, opposing this demand, well, I submitted a detailed application under Annexure 19 at page 90. Well, it says, well, no decision was taken. So I approached my lords. Well, this honorable court directed the state to obtain instruction as to what decision has been taken on his representation. So accordingly, my matter was adjourned once. Thereafter, under Annexure 22, page 100, though my representation is consists of 7 pages and there are several grounds opposing the demands, my lord, in a single line, well, this has been rejected. Not a single contention raised by me has been taken into consideration. Page 100, Annexure 22, bottom last paragraph, my reference. Whereas the royalty has been calculated on the basis of royalty plus additional charges taken to the as per OMC Rule 2016, which has been later clarified. Well, this, in fact, this is wrong, contrary to rule itself.
What?
This calculation of royalty is contrary to rule itself. Rule provides that because the whatever mineral I will remove, on that I will pay the royalty. Well, he has charged on the additional charge also. That I raised the objection in my application. That has not been taken into consideration.
Was it where is the rules which does not permit additional charges?
Royalty on additional charges.
Royalty plus additional charges.
That is not royalty is only on the removed mineral.
Where is the concept of additional charges? I just wanted to know.
No, additional charges is my lord to rule 20.
Oh, minor mineral concession rules of 2016.
Yes.
Which state?
Rule 27.
Yes.
Sub-rule 5.
Yes.
Subject to the provisions of these rules, the technically qualified bidder who quotes the highest rate of additional charge will be declared as selected bidder.
Yes. So there is a concept of additional charge.
Yes.
So,
but I am liable to pay royalty in respect to the minerals which are removed. Unless the mining operation has been stopped pursuant to order passed by the competent authority. So accordingly, the mining officer has rightly did not raise any demand for the second year, third year, as well as for the fourth year. Now suddenly this person who does not have any up 22, well, he raises a demand for that period. Amendment to my lord kind of schedule 4 of that rules. Now that is, if my lord is holding this 2025 publication, that is available at page 116. So page 116, my lord, schedule 4.
yes.
Schedule 4, my lord, serial 2. Mining officer, column 4 is mining officer of respective jurisdiction, steel and mine department. This entire schedule has been amended, substituted on 27/12/2022. Bottom is that 27/12/2022.
Is not closed.
Towards last it is there. Well, I am passing on my book.
It is still containing the old one. 25. Yes. Yes. Okay. This is also 25. In many matters, you
From the website, I tried to
sir,
get
the difficulty I tell you. This is also a book published by the Odisha Law Reviews.
I also
This
paid
is
the
also
same
a book published by Odisha Law Reviews.
2025.
But in your book, it is a 2022 amendment which is given. In this book, both 2025, only 2017 amendment is given.
That problem also I faced.
The other book, my lord, that is at page 116.
Which one?
116, my lord.
Of which book? This book?
This book, my lord.
Your color is also different. Three colors I am having. One is absolutely yellow, one is a light yellow, and this is really a light green.
116, my lord, 16 pages also.
No, there is a he was relying on that. You, Mr. Das, in many matters you have shown that particular amendment, the Gazette notification. Amendment in 2022, minor minerals, this concession.
2023 it came into force. So
Yes.
I'll produce that.
You head over to me.
Yes. In one matter, I had handed over to the court. I'll
Right,
produce
what
that.
matters you are.
I'll produce that.
Odisha minor minerals. Some immediately here. Odisha
No,
minor minerals.
This is correct. This is absolutely correct. It has come by. You are appearing. How can? In 2025, when he is robbed off, may I use the word, of all authorities, can he?
Minor minerals concession.
What? Refer to?
Concession rules 2016.
I am asking, it may be an earlier, but once the power is transferred, can he retain the power? If the power upon whom it is vested, he can go for all these things. Can he? As an adjudicatory authority. when the amendment says that all the records will be transmitted to the new department, from where he retained the records? How can he? It's a usurpation of, I say, the powers by two different authorities. One legal and another without. And then all his demands and everything is cannot. He's a mining officer. Let him make a demand. No problem.
So he is demanding 0 for that period.
Oh, whatever. It's to him what to take,
Yes,
take a
yes.
decision. He can review his own demand after gathering many materials.
Yes.
Okay, where is the difficult? But at least mining officer should do it.
Yes. Tahsildar has.
That's also a subtle principle from Taylor versus Taylor and Nazir Ahmad case. If the power is conferred upon that authority,
You can't.
we will settle it. What is it? It will.
And it is a conscious amendment that was brought by the government that they do not want the Tahsildar to be there. Obviously, there must be a very competing circumstances to brought an amendment. It's not so easy to bring an amendment. There was one thing they brought. Then well, how?
So, what happened in fact was after this 2015 amendment in the MMDRR. So minor minerals now, instead of that earlier rule, prevention of theft, smuggling, etc., in 2016 the rules were made. So earlier it was within the administrative control of the revenue department, revenue and disaster. Now there is a minor mineral directorate
Correct.
under the Steel and Mines Ministry.
Yes.
So it has already been a regular director has been appointed yesterday of minor minerals, an officer of the All India Service Cadre. There is no establishment, in fact, of this new directorate. So it is being made functional. Maybe, so I have to let me call the mining secretary and discuss.
It can't.
What is let me take instruction. You are frequent keep it.
But don't proceed on the basis of a demand.
They are not issuing the mining dues clearance certificate on
let
this
it
annexed.
Come on Tuesday. We are not passing any order, but
lots of theft in those sand miners mill. It's a racket. So let it come next week.
Mr. Advocate General, actually you are not given a facts.
So that's correct.
Only on a verbal this thing. Actually, in this case, so amendment is brought. The mining officer raised a demand for first year, second year, third year, and fourth year. On that demand, he deposited. After that deposit, Tahsildar surreptitiously took up the issues and raised a demand for first year, second year, and third. Again, when a mining officer who is in the helm of affair has already raised a demand, and the demand is meted out by pay, how can a Tahsildar again make a demand?
That's correct.
That is what is the.
No, that's correct.
So I do not think that he cannot raise a demand.
No, that's correct. Well, is very correct, but let it come next week. In the meantime, I'll call the officers today itself. We will verify what is because I do not know what is the quantum. Many such cases
question.
may be there.
Mr. Advocate General, so it's not a question of a quantum. The mining officer may subsequently raise an additional demand if it is there. That is within his authority. He can do it. But the question is whether the Tahsildar will use up. There are two simultaneous authorities exercising the power. That's can't be.
That's the proposition
That's the can't be.
of law. He cannot. Once the power has been transferred to some other authority, he suggests to exercise that power. There's no dispute on that.
Even Wednesday, my other matters were similarly my jurisdiction issue was also very item number 4.
Come on, jurisdictional issues. Wednesday. on the prayer of the state. Let this matter be listed down to that 30th. Items is
Your Lordship, I am appealing on behalf of the petitioner. Petitioner is a company who deals with installation of CCTV cameras. 4 government tenders were applied by the petitioner, and petitioner was rejected on the grounds of not giving the necessary digital signatures.
that means
So,
at the technical bid stage.
yes, Your Lordship. The problem arises when the people who were successful in achieving the bids were considered valid, but their necessary documents were unavailable. Page number 40, Your Lordship, DTCN is available, where it is clearly mentioned.
Page number
40.
40.
Yes, sir.
Bring that page 40.
Yes, sir. 4 successful.
Page 40.
Yes.
Yes.
Yes, Your Lordship. Clause 9, GST clearance certificate. Every other documents were provided, but GST clearance certificate is a mandated document. But it was not provided by any of the successful bidder. Like 4 successful bidders were mentioned, and it was annexed, but they didn't provide the GST.
Attested true copies of the valid electrical license issued from the ELBO Government of Odisha, valid GSTIN clearance certificate, PAN card and other things. So they have not given a valid GSTIN.
Yes, Your Lordship. And the
Where
major
do you
point.
get it? Where you get this?
Yes, Your Lordship. The government tender site, people can easily download from the site.
So have you downloaded?
Yes, Your Lordship.
Where you have an X?
Yes, Your Lordship.
At least there's an exemplar, one instance.
His Lordship, page 100 from 119.
Page
100 from 119. It is clearly mentioned.
119.
Yes, Your Lordship.
Yes. Yes.
Copy of the selected bidders showing non-compliance with the mandatory 115 to 150. All the results were submitted as an annexure.
Oh, what are you talking about? We are unable. What is this affidavit? What you are saying? 15 you are referring, or 100?
Yes, from 100.
You are referring.
Yes, 115 to 150.
Show us the relevant portion, sir.
Actually, it is the complete downloaded document.
Please show us a particular place where you can say that they have not submitted the valid clearance certificate of GST. I am asking
Yes,
this.
Page number 73, Vakron, who is the petitioner.
Now you have gone to page 73.
Yes, Lordship, because it is absent. The relevant document is absent in their documents.
Where do I get it, sir?
Let's say, kindly have a glance to the prayer pillar. Prayer of the.
Don't go by your technicalities. Don't let us see first. We have to satisfy our function of proposition what he is now giving. Where do I get it, sir? Or an inference can be reasonably drawn that he has not submitted a valid clearance certificate. Just we wanted that, sir. We do not want to go any other.
Then page number 152, where the petitioner has informed to the superintending engineer, it is mentioned that they have not submitted the no relationship certificate. They have not submitted the GST clearance certificate.
So
but there was
have they admitted it?
No, Your Lordship. There was clear silence from their side. They didn't respond to this notice and didn't reply.
This is the representation of the petitioner, Miller.
Yes, Your Lordship. But there was no certain reply from their side.
Rejection of your bid.
Your Lordship, page number 111. The work orders are listed.
What is the ground mentioned therein?
Your Lordship, these are the work orders which were given to Sri Jagannath Farmhouse. Sri Jagannath Farmhouse and 112 for Kishore Kumar Behera. And for 113, it's Om Engineering. And 114 for RJ Enterprises. Two of the successful, page number 111 to 114. Four work orders.
Name?
Your Lordship.
What are your names?
Sri Jagannath.
Sri Jagannath. So this letter is written to Jagannath.
Yes, Your Lordship. But with the absence of document, they were allowed for the tender.
So you were permitted to come to the office and then have the execution of the agreement.
Yes, Your Lordship. But the initial stage, which is necessary, the no relationship certificate, where it is that the.
Sir, you are relying on this letter at page 111.
Yes, Your Lordship.
11.
Page 111. Yes, Your Lordship.
You are relying.
Yes, Your
This
Lordship.
is of 7/4/2025.
Yes, Your Lordship.
Look at the subject. Letter of acceptance for the work. They have say with reference to this, it is notified that your percentage rate is such and such, being minus 14.99.
Yes, sir.
And corresponding estimated cost is hereby accepted.
Yes, sir.
By the undersigned.
Yes, sir.
You are therefore requested to attend this office within 7 days. Yes, if they accepted your, then where is the grievance?
These are the work orders, but before that, it is available on website, the results, where for accepting.
I am asking this question to ascertain a prejudice. They're not ready in the back. I think you need time to prepare yourself. Being a junior member of the bar, the bench encourages you to go through it. Please go and read the paper thoroughly. Come, say with precision, in a crisp manner, what is your grievance and what are the documents which would corroborate your stand.
I have the page number 29. It is clearly mentioned the qualification criteria. Submit bids. through e-procurement portal, the bidder shall upload the scanned copies of the documents.
You could not gather. I can't speak the language which is more understandable to you so
Yes, sir.
clearly. But the only thing is, please, you have come.
Yes, sir.
First grievance you have raised is that your tender bid was rejected.
Rejected. Yes.
The first query was that at what page or what in that order rejecting your prayer tender. You showed us 111 where we find that you have been awarded.
No, Lordship, they're not the petitioners. They're the
I
successors.
asked the name, you
Yes, sir.
say Jagannath. So I went to Jagannath. I think everybody who is here, I say, who are you? What is your name?
Yes, sir.
You say Jagannath. I
Yes.
went and I find this document is Jagannath's document.
That was a mistake from my side, Lordship.
So I thought that this prepare yourself is better
Yes, sir.
instead of hovering over the voluminous papers. It's better to prepare.
Yes,
Yes. Let this matter be
Next week.
listed on next Monday to enable the counsel for the petitioner to prepare.
Obliged, Lordship.
Want to write get this one down. Simply write. This is this one.
7.
In this case, the petitioner became the highest bidder. Also to a tender call notice on 4/6/2020 for operation of sand soil at and the lease deeds were executed on 9/7/21. As per the rule 43(2), the period will start from the date the release deed is executed.
Please, yes.
Therefore, that date is 9/7/21. Therefore, till 26 I have the lease period. While the matter stood thus, some of the villagers of the locality petition to the collector as well as filed a writ application before this honorable court, raising objection that it will be if there will be excavation, then it will danger
Ecological balance or there? Yes.
danger to their life. This honorable court disposed of the writ application directing the collector to consider their case matter. Thereafter, on 29/12/2023, their objection was rejected, and collector passed the order that the operation can be till today, my lord. I could not able to operate the lease.
Why?
Because of the fact that they have not, my lord, demarcated from where I will extravert the sand.
Lease deed will indicate. The lease
Lease
deed
deed
contains a
is-
schedule.
Because of the, my lord, delay, that 21 till, my lord, 2024, and the record was transmitted to the mining officer in 2024, my lord, by the Tahsildar. I could not able to operate the lease, man.
My lord, in the
And
earlier,
the second prayer I have made before your lordship, my lord, since I could not able to operate the lease.
Demand. That is the actual.
the last occasion, Lordship directed us to take instruction in this matter. We have sought for instruction. May I pray, my lord, matter be taken up the next week, my lord, so that we will open instruction on this matter.
He's on a civil law, she's correct. Because the lease would operate from the date of the execution. Under the Transfer of Property Act, says from the date of it should be transfer should be effected either in presentee or in future, not from a retrospect or anterior date.
Next week.
Her only concern is the demand. Not very interested in mining activities. Second.
take instruction. Wednesday, we are keeping all those matters. Please.
Wednesday.
Wednesday, madam? Yes, Wednesday. One after another. The other two matters we have just fixed earlier, just after that.
Item number 8.
8, my lord. Wait, please, my lord. This is a PIL, my lord. Where, my lord, we are seeking a direction. From Barango till Trisulia, my lord, there are speed breakers.
Can you start, son?
Sorry. My lord, this is a PIL, my lord, public interest litigation. My lord, we are seeking a direction, my lord, from Barango till Trisulia bridge. There are speed breakers, my lord, but there is no, it has not properly lighted, my lord. So those are big humps are there, but those are not properly lighted. So when we are coming through that passage, my lord, from Barango, my lord, till Trisulia, my lord, the bridge, so we are facing a lot of problems, my lord.
Why?
Because the humps are there and it is not properly lighted, that those are not properly marked.
This is a very menial issue.
My lord.
When Mr. Advocate General is here.
Yes, my lord.
So just to tell something, otherwise not impositions. Don't take it any imposition for those. Because if there is whatever, I can understand. But if a glow sign paints, fluorescent paints are painted on those speed breakers, once they come with the light, they will have the reflection.
Right.
I think
it's a very easy way of
it will be done by next day.
There is no difficulty.
Right.
That will be clear because putting a lamppost is
like
a hilarious and humongous task.
Only those
paint,
yes, my lord. Those things can be. Some paints are put on, my lord, then it will glow and it will be helpful to us. My lord.
I'll give this matter one copy maybe served to us.
Copy they do.
We get the copy.
When the learned Advocate General is appearing, your interest will be taken care of.
But there one thing, one problem. I was about to take Francis time and discuss. But the High Court said the copy of any petition presented by the council has to be served. Otherwise, that will be pointed out as a defect by the stamp people. Now what they are doing, they are not serving the copy. So we have to suppose 200 cases are being filed. The average I was inquiring what would be initially I had said that only. That costs us 2.5 crores to take out the copy. Suppose 500 pages, and it is also practically not possible to take out. So there is rule has not been amended. There was an administrative order. I do not know.
Probably yesterday, I think you were not here. Some of the members who were here, I noticed this kind of a situation. So I suggested, I have not gone into the rule. When you say there is a rule, I suggested that any writ petition must be served in advance to the respective parties, or there must be a one section where either in a government advocate's office or in the Advocate General's office, whatever, there must be a specific counter. If they receive the file, and they will generate one receipt, and they will immediately annex that receipt with the filing. And my suggestion was, subject to the bar agreeing, my suggestion was that shall not be listed within 48 hours of the service.
Right.
This 48 working hours is required because the state must take instructions. There is already an dispensation clause must be also there, that in case of an extreme urgency, this dispensation can be done by the court. Without serving also, one can move to the court, depending upon a urgency, exigencies. So that was my suggestion. If the bar agrees,
we are agreeing, my lord. Whatever suggestion, my lord, it comes through from my lord.
say 48 hours before, it will not be listed.
My lord,
What we say that at the time of filing, they have to annex that receipt, which is issued by an office of the GA, government advocate, or the AG, whatever. Suggest.
my lord, can I?
There must be a receiving counter.
My lord, can I?
They should not get. They should not have to run from pillar to post. No, there must be a dedicated office where they will receive.
That is there.
Issue a receipt.
Can I suggest one thing, my lord? I will request my Advocate General, my lord, that if he gives that thing, I will circulate throughout my bar members so that this problem is that will give the copy.
Very easy way, because I find every time the instructions for that the matter is adjourned.
Right.
So that's why if 48 hours time is given, I think that's a very reasonable time to get the instructions.
Correct. And important matters, my lord, that dispensation can be done.
Yes,
At the
extreme
discretion of the
cases,
court.
they are immediately at
My
2
lord,
p.m.
my-
something is going to
my-
happen. That
My lord,
emergency
I
provision
request-
must be there.
I request my senior, my lord, to give that thing. I will circulate among the bar members.
For copy receipt, our staff are there already. It is not, it is there. This was the practice.
Mr. Advocate General, the only thing is that there must be a sufficient number of the staffs, because the number of the filing would be used.
We can increase that pillar. That is
That
not
is
an
what,
issue.
only 1 or 2 persons, then they have to stand in a queue, and then unnecessarily the wastage of time we do not want. It should be.
There would be no issue on that. Only thing, the hard copy, we are entitled to a copy, it is not being served now. They are taking a generated printout, and that is being, otherwise, it was earlier shown as a defect. Matter cannot be listed. So we are facing immense difficulty to take out the printout, and that is also costing a huge burden on our budget. Petitioner is to serve the copy at his cost. No, that is being done, it is nothing new. Petitioner,
I think, my lord,
to serve the copy, he has to take the notice also to the private.
There is a difference. That's why I have not said anything. I kept mum.
Issued by the registry when my lord Chief Justice Nationality Saransin was there. That is contrary to High Court rule. That can't be without serving a copy on the stay. I've taken up,
No,
and
my
that
lord.
too, just
My lord, sorry.
State has to be also properly instructed. We are not having the brief. How can we take the instruction, Milord? Everybody is not techno-savvy that we will go through the LMS system and find out. And that too, Milord, it is, I was asking my office, the cost is around 2.5 crore.
Oh, that
I did not know that. It would be a burden on our budget. The government may not sanction it. So we cannot take out, we may be constrained to stop it. In the supplementary budget, I was discussing with the finance secretary, they are not willing to bear that cost. It is the petitioner's duty to serve the copies. Why should the state take up that responsibility? You will take instruction in time, but copy that.
No.
It is as per the High Court rule also.
Other issue was that has been immediately resolved, because I find that
That's correct.
it is contrary to the rules of the.
That is absolutely contrary to the
So immediately within
That-
48 hours,
Yeah,
I took up that issue,
Rule has not
and now it is
commented.
resolved.
My lord.
That automatic dismissal issue has been taken care of.
Taken care of.
First,
So
automatic dismissal, non-removable defect, that has been removed now by a standing order.
the moment it is brought to my notice, within 48 hours, I have to,
I-
because I do not want any kind of a problem that to come.
We are ensuring.
We are very obliged to that.
Let me
No,
apprise
that's,
to Rashid. Let me apprise.
Let us think about it. That
That
for
problem, my
once-
lord, can I submit my?
Let one thing you are saying. For a month, 1 month, the case diary was not called. I have set up a police station inside the office of the 7-8 personnel headed by one inspector of police, one DSP is monitoring. The next day the case diary is coming. Your Lordship may verify from the other. In criminal and the state was asking for 2 weeks, 3 weeks. By the time instruct city was coming, the person was arrested. Now the next day, I have told all the SPs virtually also. I have taken meeting with them. Within 48 hours, the case diaries would reach my office. It is coming.
That's a very good. That's a very good initiative we have taken. I expect this initiative to be taken in the writ matters also, so that the respective department gives them a proper instruction within a reasonable time.
Right.
Unnecessarily, that's.
Let your Lordship call the office bearers of the bar, and I'll be present, Mr. President and Mr. and Secretary.
There are some. You cannot segregate yourself from the bar. You are one of the integral
I am pillar.
part of the bar. Maybe representing state, but you are connected to the
concept of paperless, my lord. This concept of, my lord, the concept of paperless. My lord, the concept of paperless.
It in this case. May I pray, my lord, matter be taken up on Monday so that can be heard, my lord. Today we are.
So advance copy to her.
Yes, yes, my lord. Today I will solve.
My lord, then till then Monday there will be no, because my lord, they are delaying the issue.
You know.
Today we are.
By the council agreeing for a respondent that the
So that I can come prepared. And
yes.
Item 10.
my lord, till that no course.
Many questions will be put to you. Don't worry.
Right.
May I say, your lordship, that the petitioner, who is a level 2 handling and transport contractor, challenges the tender call notice quoted by the Odisha State Civil Supplies Corporation Limited, OSCSC Limited, regarding the schedule rate. It is given 37 rupees, but under other programs, it is 175 rupees, like in SNP and Pradhan Mantri Poshan Shakti Nirman scheme. And your lordship have also been pleased to entertain similar rate applications.
Number 4, the corporation. Similar matters, your lordship has been pleased to call upon the corporation to file reply. That has been posted to 28, that is Monday. But Monday will be too short a period for this case. If your lordship grants little more time, I will also. I have received, in fact, the Parawari's comment. I have to prepare a counter and file it. It's 28th only, the Monday. There are 3 matters, your lordship.
This matter will be tagged with those matters.
Tagged with those matters, and if your lordship pleases, can it be deferred for a week further? That much. I'll file it, my lord. I have got the instruction, everything. Cases, my lord, we have the lead case is WPC number 18300 of 2025. That is the lead case, that is WPC 18300 of 2025.
The issue is more than the history. The condition is artificial and similar to issue.
But I pray your lordship will please to direct.
Already there, any action.
And that will be there, my lord.
But your lordship may pass similar order in the.
Why necessary? Once it is stacked, then everything is.
My lord,
Once it is stacked, then everything.
Don't worry. Direct my lord. And another point also I have raised here with my lord's.
Conserve your energy, exhaust on that fifth of progress.
Direct.
Item 11.
May it please your lord. The impugned order, my lords, in this case is at Annexure 1, my lords, page 24, wherein, my lords, the technical bid of the petitioner has been rejected, my lords, pursuant to a tender which was floated by the opposite party, my lords. My lord may take up, my lords, my lord may kindly see page number 24, which is a screenshot of my. Yes. Now, your lordship, a typed copy I have given, my lords, which is at the next page, page number 25. Since this was not fully legible, page 25, I've given a typed copy. I'll just read out. Yes. I'll just read out. The bidder has uploaded. My Udyam registration, my lords, is a certificate which is granted to an MSME unit, my lords, and by virtue of that, my lords, I am entitled, any unit, yes, EMD exemption I can claim for. Now, they say, my lords, that, my
So it is not matching with the
category of work.
of service.
The scope of work, it is saying that, my lords, the services that I can offer, my lords, the nature of service, my lords, my Udyam certificate is at annexure number 3. The scope, my lords.
Tender document.
Yes, tender document, annexure number 4, and the relevant page would be, my lords, page number 40. 40, my lords. Tender notice, description of work. May I read it out, my lords? Yes. Comprehensive annual. My
Yes, and there is a certificate.
certificate, my lords, is at annexure number 3, which is, my lords, that I can give, my lords. This is at the bottom portion. Various, there are 5 different kinds of services that I can. Yes. So my point basically, my lords, is in the previous year, this tender was floated by Mahanadi Coalfields, the present tender. In the previous year, on 24/4/20 If a tender was floated by Mahanadi Coalfields, wherein for similar nature of work, I would not say 100% similar, but almost similar, and that your lordships will find, my lords, at page number annexure 12 at page number 368. Annexure 12, page number 368 of the brief. And the relevant page would be, my lords, at page number 373. Again, page 373. This was a tender issued by the same authority, wherein for a similar nature of work, your lordships may kindly compare operation, maintenance, cleaning, security arrangement of 15 MTY CHP circuit, then conveyor belt, all almost similar. In this tender, my lords, I had participated along and submitted my bid with the same Udyam registration certificate, my lords. And I was declared to be qualified at the technical stage, my lords. Though I was disqualified, my lords, at the financial stage, my lords, I could not succeed. But at the technical stage, my lords, I had succeeded with this just 1 year back. And after 1 year, my lords, they have held that, my lords, my certificate does not match with the work that is being offered. Present page number, my lords, annexure 4, page, it starts from, my lords, I'll just give the page number 40 is the relevant page. 40, my lords. Starts from 37.
Yes. No, I am for the opposite person, number one, Secretary Minister of Coal.
They have a separate panel of counsels in the High Court, my lords. Yes, yes. Now, my lords, they are going to finalize the tent. Some I'll take notice, my lords, or to the council to my lords, I'll do that. I'll
Item 12.
I'm grateful, my lords.
May I please, your lordship? This is just the petitioner has challenged the condition as triple notice by the annexure 2, my lord, as well as in annexure 3, which was the tender now plotted by the Cuttack district, my lord, for appointment of level 2 transport contractor. Level 2 transport contractor, my lord. Transport contractor. For transporting of PDS commodity, my lord. There this price has been fixed, which has been too low, and apart from that, workable rate has been fixed in an arbitrary manner. Though the similarly situated transport contractors are getting more workable rate for the same transportation of the PDS commodity for school points. Apart from that, there is a clause they have fixed in clause 8.1, my lord.
At page my lord 127, my lord. 26, my lord. 6, my lord. My lord, there is a second paragraph. If the rate quoted by the bidder is less than 15% of the tender amount, then such a bid shall be rejected and the tender shall be finalized on merits and accepted. No, my lord. No. In a separate, in this issue, my lord. Fixing of the rate, my lord. So, other cases are pending. Your lordship has issued notice in that cases. 8.1, your lordship may see.
Less than 14%. So there was one case where 14.99 or 15.1.
Yes, my lord.
I think that was a
if
I remember.
Yes, my lord. There is a judgment in that issue only. Yes, my lord. Yes, my lord. I am sorry.
Judgment if I
Yes, my lord.
right.
Yes, my lord. But 8.1 next clause, what they have stated, there is a necessity of two vehicles. If a tenderer having registration certificate, he can apply. They can force the tenderer to install the equipment GPS enabled vehicle location tracking device in those two vehicles. But the vehicles which he will hire at the time of transportation, he cannot ensure that those persons will install the device.
He says that it should be registered.
His name next. Yes, ma'am. Instant GPS enabled vehicle location tracking device can be availed on higher basis, my lord.
No. Minimum requirement.
Yes, that is.
You should
Yes. One have two vehicles.
Additional, you can hire.
Higher, but
Whether your two vehicles
yes.
GPS enabled.
Yes, my lord.
Is GPS enabled?
We will supply the GPS enabled vehicle.
Supply means.
Well, because at that point previously that is not there. This year it has been inserted, my lord.
You see, they
Yes.
must have faced some difficulties later on. Keeping a track of the movement of the the vehicle. GPS
they can post this clause to two vehicles only, but the higher vehicle we cannot say. But in the instant, which vehicle is available?
Says that additional could also be installed.
Installed. How can we will ensure the person from whom we will?
Then you have to hire those vehicles which is.
And in the state there is no rule, such rule that all the vehicles, all the trucks will install. But for that reason, it is difficult, man. Illegal and arbitrary. And apart from that, no, for two vehicles that is there, my lord. For which is owned by me. Ensured, because a person, they are saying in one day we can lift four truckloads of commodity. If I will hire a vehicle from the market, my lord, if he has no GPS enabled system, and I cannot hire that vehicle and I cannot lift the commodity on the same day. There is a condition, disqualification condition. If I will not do the same, then I will be disqualified. No, my lord, that is not the state rule. State rule is done. My lord. I don't know, my lord. That is not that.
The car is also GPS. Yes. Your car is also GPS.
Yes, my car is GPS. Trucks are coming with GPS, my lord. Yes, ma'am.
Where is the discriminatory clause?
Your lordship may see the appendix 151. Well, the rate they have stated, it is schedule rate. Your Lordship, page 151. The appendix 1, page 151, my lord. Schedule rate, though in respect of midday meal and other programs, they have fixed it 158. The schedule price is 150, highest selling price, my lord. Here it has been fixed 34.51. Highest is 46.21, my lord.
They are fixed per quintal.
My lord.
They are fixed at per quintal.
Per quintal, madam. In respect of midday meal and others, it is fixed. Your Lordship may see annexure 6, page 214. First is, my lord, annexure 5, page 212. Government has enhanced the rate on 27/1/2025. Transportation cost for food grains under supplementary nutrition program, my lord.
$150 per quintal.
Yes, my lord. 75 to 150 per quintal. The selling price has been made. And in respect of midday meal, the last tender of the Cuttack district, I have given 214, my lord, page, where it has been also 150 is the selling price, my lord, page 216, my lord. And in this issue, your Lordship has issued notice in other cases and fixed to 28/7.
But item 10 deals with the same point. Now your Lordship has been pleased to defer. This point my friend is raising. Here I have not been given a copy, but I had the occasion to go through the brief of my learned friend for the state. Yes, OP2.
No, there is a panel of counsel.
No, I should be given a copy. I have been instructed.
My lord? No, my lord, it is the Civil Supply Corporation. Always notice has been issued by this honorable court.
In fact, my friend has been instructed to engage me.
I could have served today only, my lord. Yes, my lord. Your Lordship has...
No, 10 days after.
No,
Monday it was there. Just now your Lordship passed a judicial order.
Monday it was there, my lord. This is the case number, my lord.
My lord, your Lordship granted 10 days deference.
Yes, my lord. 5th August.
10 days after your Lordship.
My lord, I have filed an IA in this because tender has been floated and subject to result in that case your Lordship has passed. I may pray in my case that order may be passed, my lord.
Is that the matter or?
My lord, it is not autumn because in those cases they have challenged the proposed tender. Here the tender has been floated by the Cuttack district, my lord. For that reason, I want that order should be only subject to result, my lord, only.
Item 13.
Obliged.
May I please, your Lordship? My lord, kindly see page 10. May I please move? This matter relates to issuance of single stroke multiple financial agreements. Yes, ma'am.
20.
My lords, I appear in item number 20. My lords, I am seeking an accommodation in the matter, my lords. The arguing counsel is in some personal difficulty, my lords. My lords, may kindly list the matter next week, at your convenience.
Copy has,
My lords, I will,
has not been served.
my lords, I will serve the copy in the course of day. My lords, my lords, a small request, my lords. Can the matter be listed next week, my lords? My lords, because recovery, there are I understand, my lords. Yes, my lord. Not be able to justify.
Item 21.
May I please be lodged? Here, my lord, the appeal has been rejected for the delay of 16 days within the condonable period, my lord. Condonable period. And the medical grounds, my lord, has been taken as the ground.
Your lordship has, your lordship has, your lordship,
very expensive order.
your lordship. I have tried
No, I've,
as my senior.
I think the gender.
To assist my lord in senior.
So I'm grateful to my lordship. I came to learn from him that your lordships have passed this ordinance. Grateful.
Item 22.
Please, Your Lordship. Your Lordship, I'm seeking permission to withdraw the present writ petition, Your Lordship. Since in the pendency of the writ petition, no stay was granted and the opposite parties have already been operating the sand quarry, Your Lordship. Obliged, Your Lordship. I filed an IA, Your Lordship.
Item 23.
My lords, I seek the permission to withdraw this application to file a better application to bring all the material. I filed an IA. Liberty may be granted.
Item 24. Twenty-five. Item number 26. Item number 27.
Your Lordship, item number 26. Signature is just coming. Just
What about condemnation? Have you served the copy?
so,
What is issued on condemnation?
sorry, Your Lordship, I'm not.
I'm not aware. And you have come before us. First time appear.
Yes, Your Lordship.
Some condemnation. Returnable after 2 weeks.
Fine. Item 27.
Application served.
Yes, it is did serve.
With appearing for the other side.
The one Mr. Sanjat Das, who appeared before the learned single judge also.
Oh no, yeah. Have you served the
Yes, my lords, I have served the copy as per the procedure. I do not know whether he is the assigned person as of now, my lord.
There is a report.
Service report. Service report. Service report. Other side to the client.
So there is no direction for issuance of the notice.
No, this is first time, Lord. It is appearing.
It has to be given on condonation application.
Right. Only the but the condonation, Lord, is actually
5 days, 4 days.
No, my lord. It is not even the delay. I'll tell you, my lord, the date of 30, my lord, it fell on the vacation, the holiday. So succeeding date I find. So
on a reopening you filed it?
Yes, my lords.
Or a 1 day after reopening?
No, my lords. I'll tell you, on Monday, my limitation fell. That is on the 28th. I filed on the 29th, my lord. I filed on the succeeding day. The order is 28th of March. Then my limitation, my lords, the Saturday was off, Sunday was off, and then the Monday was also off. Therefore, the Tuesday I filed it. There is no delay. It took a lot 1 month to extend this fee.
It is 3 days. That means it expires on Friday.
No, my lords. I'll tell you.
No, means?
My lords, let me humbly submit, my lords.
Then I will tell you that you have the copy of the Limitation Act now.
Yes, my lords.
Please read section 12.
My lords. My lords.
How to compute the
Correct.
Please. How to compute the limitation. Read section 12. Not the from 28 to 28.
This is
section 12 of the limitation.
Yes, my lords.
Please read.
Subsection 2, in computing the period of limitation for an appeal or an application for leave to appeal or for revision of a review, the day on which the judgment complained of was pronounced and the time requisite for obtaining a copy of decree, sentence, order, appeal from a sought to be revised. Subsection 1 says, well, in computing the period of limitation for any suit, so and so, the day from which such appeal is to be reckoned shall be excluded. This is an exclusion.
Then 28 will be excluded.
Correct.
It will start from 29.
Right.
Then,
my lords, subsection 2 says that the day on which the judgment was rendered, it has not to be computed. For obtaining a copy of the judgment. Correct, lords. Where a decree or order is appealed from a sought to be revised or reviewed, or where the application is made for leave of the appeal from a decree or order, the time requisite for obtaining a copy of the judgment shall also be excluded. Then, in computing the period of limitation for an application to set aside an award, so and so shall also be excluded. What my humble submission is that 28th of March is the date of the order. I have not applied for the copy. It was available, my lords. It is made available in the uploaded in the website is somewhere around 15th of April. According to my lord findings, I have stated in my application, it is 15th of April. I got it from the website. So pursuant to that, I filed it. But even if I'll calculate from 28th of March, that's the date of the order, your lordships may exclude that date, then my computation will end on 27th. 27th, my lord, is the Saturday. 27th of April. So therefore, my limitations extended right up to the Tuesday because Monday was also the holiday. That is about 28th of April.
Oh, yes.
That was a lawyer's day.
Yes.
So therefore, I filed it on Tuesday, my lord. That is on 29th of April.
Yes, filed it on 30th, sir, not 29.
My lord, the
not 29. Acknowledgement is of
my lord,
30th.
My lord, it is actually 29th. They have shown it in the website is 30th. My lord. That I have a receipt, my lord, on 29th.
Of the department. Of the department. How can this be done?
We have explained for 1 month, but they still insisted that.
No expression. You have really filed it on 29. Why the acknowledgement will show that you have filed on 30th. Question, very important because of section 3, you have to get this first.
My lords.
That writ appeal, your lordship permitted to file document, I have twice. And the interim order, your lordship, listing order is continuing, so next date of listing.
If we continue in the next week, it will be on Friday.
Let it go.
Any other day, because not on Friday, Friday we're not getting time.
Everything, whatever matter will speak.
But I've missed item 26, my lord, just the item.
Yes. Specialist item number 1.
Who's last? Defects are not removed. So administrative notices to be issued, already issued. Where is the service? Service is exact office is situated. None appears. Dismiss for the point.
Item number 2.
Let's see. Here is case, my lord. The PLR number 13 that instead of a 1, so that the requisite is not filed but it not. Let's see this. Kindly go to the orders. The PLR number.
Where is the order dated 6/10/2009?
6/10. Yes, that is
You
there,
are
my lord.
challenging an order dated 6th of October 2009.
Yes, my lord.
Where is that order?
That the 6 and my let's see go to the order passed by the non-civil judge in execution case, my lord.
That is annexure 8.
Yes, ma'am.
8, page 111, your lordship.
Yes, ma'am. That is order passed by civil judge senior division cancel, my lord.
Yes.
Let's go to the it is arranging to execution case, my lord.
Yes. Who is appearing for the petitioner?
This one.
I am for the opposite parties.
Petitioner?
My lord, I am for the
Yes. How can you sustain this order? There was already a partition suit which was instituted way back in 1970.
Yes.
There was a preliminary degree. The preliminary degree, the final degree was passed.
Yes.
After the final degree, it was engrossed on the paper. You did not divide the property by metes and bounds. Then the execution was levied. Execution ended with satisfaction that the property is simply a suit has been filed somewhere challenging. You go and ask for an injunction or a stay there. While the execution proceeding will remain stay.
One thing is,
if there is any fraudulent act, you have asked for a degree to be declared as a fraudulent one, go before the suit court, not before this. Can't.
Yes, all cases.
Not.
Yes, ma'am. So all.
Promises. 151 is to be misused. Simply one suit is filed. What is this application? 227?
Yes, ma'am. 227.
Yes?
Yes, ma'am.
This is an application under Article 227 of the Constitution of India, assailing the order dated 6/10/2009, passed by the Civil Judge Senior Division Kyonja in it's an execution case.
Yes, ma'am.
What is the number of the execution case?
8 of 2007 and 9 of 2007.
Page 10.
In an execution case number?
Page 113.
Page?
113. The execution number is mentioned in this.
However, the application was filed in the civil suit number 79 of 2009.
That is what I'm very surprised.
Your Lordship.
Yes.
How can an execution be levied without registering the another execution case numbers? They were passed by the civil in suit civil suit number 79 of 2009, by which an application for stay of the execution case number 8 of 2007 and 9 of 2007 is dismissed.
The item 3, the sole question involved whether
Which is the order which is assigned here?
the impugned order is will also get
The WP, right? Yes.
that is the annexure 4. It starts from page 32. That is the
32.
order passed. Yes, the relevant portion is 35. That is the order passed by the learned trial court. Against that, my lord, the revision was referred, and in the revision it was confirmed. The issue was whether the final decree proceeding will abate after consultation of after notification of the consultation.
What notification of a consolidation?
Yes.
What is that?
Consult.
It's a reverted one. How can I read it? Who has? Is 32.
Page 32, my annexure 4.
Oh, this is a suit. This is an order. Yes.
Order, my lord. The lordship. Lordship may turn to page 35, man.
Yes. Where is that? Where is the other side? Where is the other side? Anybody is appearing for the other side?
Just notice was it's a list.
Hmm? Where is he? Can you inform, because this relates to a Consolidation Act.
Yes, sir.
And I'm also very surprised to know that whether the preliminary degree is an executable degree.
Yes.
My understanding of law is that the preliminary degree is not executable. It is only the final degree which is executable.
Yes, sir. The application for final degree was
For this reason, the entire proceeding is dropped.
Yes, application for final decree was filed.
Absolutely, that is dropped.
That has been dropped. That should
How
not
can it be?
Yes, sir. That is.
I just that's why I
Yes,
want
I
the
will
other
inform
side.
my others. I will
Other
inform.
side, because
Yeah,
give a notice. There is no appearance on behalf of the
Item 4, my lord. But there is no instruction.
So dismiss for default.
Your lordship may say no instruction.
Then what? Either you appear or you do not appear, whatever is up to you.
Since I have no instruction, I can't appear. My name is there. That is why I said that there is no instruction.
Record his name. Appears and submits.
Five.
Lordship, in item 5, I seek your permission to appear through VC. Lordship, some time may be granted to ascertain the status of the parties.
Why?
Lordship, this is a very old proceeding.
So what? Nothing has come before this court. Why you want a status to be ascertained?
This is the final decree proceeding has been stayed.
Why it is stayed?
Because there was an application under Order 20, Rule 18.
For what? Order 20, Rule 18.
For decree in a suit for partition of property or separate possession of a share. Was allowed and the petitioner, the defendants had preferred a.
How Order 20, Rule 18?
Yes, Your Lordship. Your Lordship, impugned order is at page 35.
So preliminary degree has already been passed.
Yes, Your Lordship. It is in the final decree proceeding.
Now Order 20, Rule 18. Does it come under the first rule, sub rule 1? That it
Lordship,
requires the payment
Lordship,
of
that
revenue.
Lordship, we were the opposite party before the learned trial court. We were aggrieved by the order of the learned trial court in the final decree proceeding. That is why we have filed the present application.
Which for the other side? Which for the other side?
No, sir. I have
Yes, they are appearing.
Oh.
Huh? Yes.
Can you give a notice? You are a petitioner here. Give a notice on the advocates who appeared for opposite number 1 to 4.
I'll do so, Your Lordship.
Same order to give another opportunity, none appears. They are the opposite parties. He is directed to serve a notice indicating the matter will be listed on the next slide.
Obliged.
Number 6.
Item 6, I am for the petitioner, Your Lordship. Your Lordship, here I am challenging the appointment of commissioner in civil.
Yes, where is the order?
Impugn order, Your Lordship, is at page 39, Your Lordship. 39, Your Lordship.
39.
Lordship, in fact,
Is there an execution case?
Your Lordship.
Is there execution case?
Your Lordship,
What
actually,
is the nature of the decree?
Your Lordship, the right title and interest was declared of the plaintiff, who is the opposite party in the present date petition, Your Lordship.
Then how execution lies?
Your
Can
Lordship,
a declaratory degree be executable?
Your Lordship, actually, Your Lordship, that was passed in 2008. 17 years have been passed. Actually, Your Lordship, we have no instruction whether the that proceeding is still alive or not. So, I may humbly request Your Lordship, if Your Lordship may kindly take it up after 1 week.
Asking you a very simple question. Decree simpliciter for declaration of a right title and is executable.
So actually, there were twofold prayer in that.
Was there any injunction also, permanent injunction?
Permanent injunction was there, and Your
That is
Lordship.
executable.
Your Lordship. Your Lordship.
So what has happened?
Your Lordship, actually, we have no
What
instruction.
the court has done?
They
You
have.
are a petitioner.
I'm for the petitioner, Your Lordship.
If we do not find any infirmity in the order, then why we will chase the opposite party?
Your Lordship,
satisfy us.
We have no instruction whether that proceeding is still alive or not, because 17 years have been passed. So I request Your Lordship may take it up and take instruction about that, Your Lordship.
Item 7.
Obliged.
This is against the
which order is under challenge, sir?
The order annexure 7, page
7.
46. Where the
Just give us 1 minute time. Give me 1 minute time. Just to go through. Hurriedly I am going through. It's for the other side.
My lord, may I pardon to mention, my lord, in this case, the petitioner number 2 and the OP number 3, 4, 5 already died, my lord, since last 5 years, my lord. And also the suit is of the year 2001. Whether the suit is there or not, that I.
So it has abated if they have not taken any steps, sir.
My lord.
If you have not taken any steps for substitution, sir.
2, petitioner number 2, then 3, 2, 3, 4, 5.
My lord, I have no instruction. I'll take steps after verifying. I don't have no instruction.
Then it has abated.
No, I will file petition for second abatement, but we
will record the abatement. Can you disclose the date of the death?
My lord, since date, though not the date of death, but his son said that since last 6 years he died. This is my lord. My lord, only
Rule 10A, it is your obligation to.
My lord, only yesterday night I.
So why you will not communicate to him?
My lord, only yesterday night.
I paid 2 times.
What is that name?
2 times.
The learned advocate appears for the. You are now representing whom?
I am for the opposite parties, my lord.
Your clients died.
My lord. My lord, I am for 1A, 1B, C, D, E, and 2A, B, C, D, E, F.
Who died?
Died, my lord.
3, 4, 5.
My lord, petitioner number 2.
Date, sir. Expunge. Yes,
no, petitioner number 2, my lord. Petitioner number 2.
Petitioner number 2 died.
My lord.
2.
Then my lord, 3, 4, OP number 3, 4, and 5.
OP number 3, 4, and 5. Yes. Such and such appears and submits on instruction that during the pendency of the instant proceeding, the petitioner number 2 and what is this? 3, 4, and 5.
The other petitioner is already dead, so
When he died.
When he died.
When he died.
On last night I got the information, so.
No, what is the date of the death?
Don't know about the date.
Next week. Record his submission, but his name that submits that the sole petitioner expired during this application.
No, in the meantime, we'll file the substitution.
Whatever.
It was against an setting aside of an ex parte order. Decree was passed in the year 1979, my lord.
Setting aside of the
ex parte order. He filed
order what?
Ex parte order and judgment by the Land and Civil Judge Senior Division.
Decree.
Sorry,
Decree.
Ex parte decree.
So instead of order 9 Rule 13, they have come.
No, order 9 Rule 13, they filed an appeal. Appeal was also dismissed.
Order 9 Rule 13 was dismissed.
Dismissed.
Then appeal was filed.
Appeal was also dismissed.
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 Against that they have come.
They have come, my lord.
There is any stay.
But
Can you say that when he died, so that we can record the abatement?
But I do not know the date of
Then
death.
come in the next.
79 decree of the year.
Sir.
My lord, my lord.
Item number 9.
Grateful, my lord.
9.
Item 9 and 10 on behalf of Mr. Sukumar Ghosh, kindly a short adjournment is required, my lord, because he is suffering from viral fever. He requested me over telephone, my lord. Any short adjournment.
Prayer next Friday. Next Friday.
My lord. 9 and 10, both.
Item 11. Item 11.
I have challenged the rejection of the petition order 42 rule 4 CPC.
Order
42 order 22 rule 4 CPC.
42.
22.
22
to rule 4.
Lord 6 rule
Rule
74.
4.
And also, my lord, the order 1 rule 10 petition.
Substitution on the death of the plaintiff
Only sole respondent.
or defendant.
Sole defendant.
Order 6 rule 70.
No. Order 6. My lord, I have filed this, my lord, that challenge that this position. What happened? Sole defendant died. According to official records, sole defendant died. Sole defendant is represented by 2 sons. Two sons by 2 power of attorney. They are the power of attorney holders. Suit for declaration of right.
Where is the impugned order? You have annexed the
Impugned order, my lord,
whole order sheet.
Order
You have
sheet,
annexed
I
the
have
whole
filed-
order sheet.
Yes, my lord. I have
11/9/2015.
at page 63, my lord. 11/9/2015.
Page
63, my lord. 63.
Yes, sir.
My lord, I am taking to a lawsuit to page 67. ma'am. Prior to the death.
Yes.
may I take to the relevant position because a common order has been passed on 5 petitions by the Lord and
So I am also very
my lord, yes, my lord, 5 petitions.
grappling with this because the repetition of the same facts.
Repetition of some.
What is the crux of the matter?
Crux of matter.
What is the suit for? First,
suit for declaration of right title interest and for permanent injunction. If the petition plaintiff is
you are a plaintiff.
I am the plaintiff.
Sorry.
My lord, when I came to know in the 2015 that defendant from the official record that the sole defendant died prior to 1999.
When the suit was instituted?
In 2014.
14.
Yes.
So he was dead at the time when
at the time of filing the suit. I filed a petition under Order 22 Rule 4 without filing a petition for abatement or setting aside abatement and limitation. My pleading was that as the plaintiff died prior to the institution of suit, Order 22 Rule 4 I filed 2 sons are on record. I want to brought another son. That person died.
No, the 2 sons were also there in record.
Their power of
Please let me have the clarity of this. You instituted a suit against the sole defendant or 3 defendants?
The sole defendant.
Sole defendant.
And sole defendant,
according to you, was dead in 1999. So he was a dead person was pleaded as a defendant in the suit.
Defendant.
Then where two sons comes? I'm just asking.
2 sons. The sole defendant is represented by 2 sons through power of attorney. The 2 attorney holders.
2 sons have executed a power of attorney in favor of a third party.
No, man. Father executed a power of attorney holder in favor of 2 sons to represent the suit.
Correct.
Then, after coming to know that this sole defendant died, I filed a petition Order 22 Rule 4.
How this power attorney came to know? How you know power attorney? When it was executed?
That is not on record. My land. It was executed.
You have instituted a suit in 2015. According to you, the father died in 1999.
7 to 2014, my lord. 7th power of attorney was executed on 7 to 2014.
How? Because the person died in 1999.
My lord, they say, my
who executed?
I am coming to that.
Tell me.
I am coming to that, my lord.
How?
My lord, I am coming
who came from some other?
No, I am coming to that fact, my lord.
Stratosphere and then signed it.
According to the my lord plenty, the sole defendant is dead, my lord. According to that, the 2 sons are representing the suit. They say that sole defendant is alive. Court asked a person, the advocate for the defendant, produced a person identifying that she is alive and identified that has been reflected in the order. But official record since 1999 shows that he is dead, my lord. I am placing that portion only. You understand?
I understand.
Now
I will put a question.
Yes.
You complete.
Yes. My lord, that on the ground that sole defendant is alive, the petition Order 22 Rule 4 as well as Order 1 Rule 10 petition, 2 petitions I filed. Both are dismissed, my lord.
Rightly dismissed.
Dismissed.
Rightly dismissed.
My lord, I am placing.
How Order 22 4 lies?
My lord, therefore I filed Order 1 Rule 10 to implement legal error.
If the suit on the very first day is initiated against a dead person,
yes,
can the suit be made competent?
My lord, they say that the defendant is alive. My lord, I am placing that portion of the order. My lord.
You are saying that he is dead in 1999.
99. I am not, my lord, only I am placing these portions of order. Kindly bear with me, my lord. Your lordship kindly come to page 67, my lord, of the brief. Official place. It is clearly mentioned and described in the said document about the address of Executor Chandra Maji as well as the mentioned mutation case number 4291 of 1999, the Lord Tahsildar specifically stated in his order that Khatadar of Khata number 91 Purnachandra Majhi, the sole defendant, was dead, duly supported by Amin report by order number 9, order dated 9/8/1999. As per the said order 9/8/1999, it is crystal clear that Purnachandra Majhi, the defendant number 1, dead prior to 9, and it is very peculiar to note how will today the Tahsildar Berhampur still issuing ROR in favor of said Purna Chandra Majhi by Khata number 174 oblique 2018 dated 24/1/2014, publication in newspaper on 28/7/2013, and ceased receipt etc. Besides that, he so-called power of attorney that was filed before this honorable court by him on 7th about alive of the dead person, Purnachandra Majhi, and accordingly the court proceeding by civil suit number 427 of 2010, MN number 13 of 2010, and SRP proceeding before the Joint Commission, including the proceeding before the Honorable High Court, as well as the demarcation case 114 of 2013 before mutation officer, sub-register, Berhampur, etc. The petitioner Purnachandra Majhi, represented as alive, very well knew that he was dead prior to 9 as per the records. Well, that your lordship, I take your lordship to page 73. Second paragraph, on perusal of the case records, it is revealed that by order number 15/7/2015, as per the direction of this court, the defendant Purnachandra Majhi appeared before this court personally, being identified by the counsel. It is settled position of law that
the defendant personally appears.
Appeared, they say. That is the my lord, that neither Aadhaar
then
card.
what?
Then my
he was
lord,
alive.
he is alive according to this. But official record says he is dead, my lord.
So what? Whatever.
Then this is personally being identified by the counsel. It is the settled principle of law that who assert that person alive or dead, burden of proof lies on him. But the plaintiff has failed to prove the same further through the petition.
So he is still alive.
Still alive, according to the.
So why, how order 22 lies? Why order 1 rule 10(2) will lie?
My lord, all official and judicial proceeding, it is so.
Sorry.
My lord, then your lordship make it clear, my lord, that.
What clear? It is already clear from this judgment. Which portion you read?
My lord, page 73.
73. That's all. If he has recorded, what is your stand, sir? You are representing the defendant.
Yes.
He is alive.
My lord,
He has executed a
He is alive, I don't know case, my lord.
My lord, your lordship kindly see.
Forget about it. I am asking you. You are representing the defendant.
He is alive.
He is alive. He has executed Vagalatama in your favor.
Yes.
So finish. Matter ends. What more?
That's your lordship. That I want that order.
The plaintiff appears to have been
I am not disputing
I
that.
can give you a federal court judgment, the Privy Council judgment.
My lord, first time after 38 years
And
of
Order
my
22
practice.
Rule 4 lies when during the pendency of the suit, if somebody dies, then
Yes, my lord, I know, my lord, that.
That is what.
And that was therefore I submitted that for first time in my career of 38 years practice, I came after such type of case.
No, yes.
Item 12.
Call the 12.
Item 12.
Counsel for the petition of Mr. Ambassador Behra is no.
Yes.
Counsel for the petition of Mr. Ambassador Behra is no more than 2 to 3 years back.
He was the advocate on record. He has filed a Valatama. It is informed, it is for that the advocate on record of the petitioner name.
Item 13. Item number 13.
Opposite one.
Who is appearing for the petitioner, madam?
So, old case. This is against the order dated 24/11/2000.
Is it still alive or dead? This is the judgment which is challenged here.
Civil death of civil cases in Odisha. Because 40 years cases are also pending. So we are not.
No,
I also do not
here a
know
judgment.
if it is dead or alive.
What is this? A judgment passed by a civil court is assailed in the
Not
27.
Appeal. In the appeal was dismissed for default. Then they filed this present appellant has filed a petition for restoration.
No, order 41, rule 19 or 20
No,
of it.
he has not filed that.
Then?
He has filed under 151 that was dismissed.
Nomenclature, wrong putting of section,
Anyway,
not
I
a
also
fatal
do
one.
not comment on that.
Yes,
But
then
what is the explanation given? That the very day I have filed Hazira, 2 other cases were there or for the same court, and the aspersions have been made against the court that I was given the impression by the judge that all of my other cases have been adjourned. Looking to that, the judges dismissed that because it is not in the interest of justice, nor the.
and you are fighting since 2015, more than 10 years for this.
Because I
Who is
told
for
that
who is
for
for the-
10 years it was not listed. I am happy.
For the petitioner.
That's it. Practically, what happens?
Oh, it is brought to our notice that the advocate in the court of the petitioner has since been elevated.
Or 14. Item 14.
Anybody appear?
No.
Passover for the first day.
Item 15.
There is the case I am for the petition. The case is that not filing WS within the time. Without pleading, how can I lay the evidence? Trial has not commenced, issue has not been framed. This is my case, madam. Your
I could
lordship,
not get it, sir.
Pardon, madam?
I could not get it, what you said.
case has been rejected. The WS
has been rejected.
For WS filing of WS and assistance petition for yes, I am a defendant.
You appeared in the suit.
See,
you did not
file
file the
WS.
written statement within order 8 rule 1.
Yes.
Time limit.
Yes.
Did you file the written statement subsequently for
Yes.
acceptance?
Yes.
Say that I am unable to point
Sorry,
out what you say. Then the court has refused to accept.
Yes.
This is what your case is.
Yes.
And you are fighting since 2015.
Yes.
When was the suit instituted?
Suit is of 2014.
14.
Yes.
After 2002 amendment.
Yes. Your Lordship make a impugn order.
Is the application.
Application, yeah. I am giving the
application for acceptance.
My objection and also petition. Petition and objection.
Your client is a weak-hearted person or a strong-hearted person? Tell me.
I didn't have a contact with my client now.
What you understood from him? He's a strong man or a weak man?
He's now 65 years old.
Have you seen the ground which you have taken?
Yes.
That a false and frivolous allegation.
Yes,
suit is filed.
Yes.
So that make him to become ill.
Not only that, the criminal case has been filed in SDJM and also operation of legal ailment. That region that I am.
What is the recent judgment?
Recent
about
Bharat Lakra case.
Kailas versus Nanku.
Kailas versus Nanku and Salem district.
No longer.
Salem district bar.
No longer, sir.
Yes.
What is the recent trend?
Recent statement that three-judge bench judgment, my lord. That is Desraj case. If any cogent reason has been the three-judge bench, S.A. Bobde and Justice Gabai and Suryakant judgment. If any cogent reason has been said, take a lenient view. A cogent reason is that due to police case pending, I was arrested and put in the jail. And
when you were arrested or put in
yes,
after service of summons in the
yes. The learned court has taken in his judgment, my lord.
For the other side.
Other side is not that.
Who is for the other side?
Mr. Behra, R.N. Behra.
Mr. R.N. Behra. Do you know? Can you secure his presence?
I will inform him next week. We will inform.
Inform him.
That may be kept on record,
and bring the judgment of Justice Rishikesh Rai also.
Yes.
Item number 16.
May I please your lordship? Here, my lord, the petitioner filed an application challenging the order passed by the trial court rejecting my application for acceptance of WS.
Out of time.
My lord, out of time.
How much delay?
Delay, my lord. Though there is no mention the period of delay, my lord, but as per my calculation, that is
no delay of in filing the written statement.
My.
Yes.
That is 8 months, my lord.
What? What has been done? Without a written statement being filed, he was allowed to adduce evidence and you cross-examined him. The person or defendant is supposed to prove what he has pleaded in the written statement. And you have cross-examined and permitted him to give the examination in chief, and then you cross-examined everything on point.
My lord, sorry.
I'm really surprised with this.
My lord, I am the defendant number 2, not 1.
Then who has been examined and cross-examined?
My lord, the plaintiff, my lord. Cross-examined by the defendant number 3 and 4 and defendant number 1.
You are a defendant number
2, my lord.
And who are the defendant number 1 and 3?
My lord, one is the stranger to the family of the plaintiff and defendant number 2 to 4. Because plaintiff and defendant.
Number 1 is, I understand, the stranger.
My
Right? Defendant number 2 to 4
are the brother and sister, my lord.
And what is the suit for?
Suit for repurchase the suit land.
Reconveyance.
My lord. Because the plaintiff and defendant number 2 to 4.
So defendant number 3 is already there. He has filed a written statement.
My lord.
And who executed of
in favor of the defendant?
I think when he reconveyanced means there was already a deed of sale which was executed by the plaintiff.
No, my lord. Defendant number 2.
Plaintiff in favor of the defendants.
Defendant 2 in favor of defendant 1.
Defendant number 2 in favor of
defendant number 1.
Defendant number 1. And what about the plaintiff? Who is the plaintiff?
My plaintiff and defendant number 2 to 4 are brother and sister.
Oh.
This is the joint family. Defendant number 2 sold his share to the defendant number 1, who is the stranger, to the family of the plaintiff and defendant number 2 to 4.
Why you did not file a written statement? Or it is all the defendants collectively they executed a sale deed or what?
Only one.
Two alone.
Only one. And he executed the sale deed in respect of his share, not the whole share.
So what do you want to say?
My submission before your lordships that it is a joint family property, but subsequently after death of my father, it was a partition between the parties, plaintiff and defendant number 2 to 4. And accordingly, I sold my share to defendant number 1 as per the share mile.
Oh, this is a suit for preferential right under section 22 of the Hindu Substitution Act.
Right.
After such a long, I could gather one line. Reconvey. C is the assertion of a preferential right under section 22.
My lady, if your lordships kindly see the prayer of the...
What is written statement has not been accepted.
No, my lord. I put it, my lord.
So, defendant number 1 has already filed the written statement.
My lord.
Defendant number 3 has already filed the written statement.
My.
And you are not repudiating your act that you have not executed the sale deed. Rather, you are accepting that yes, you sold your allotted portion to the defendant number 1. What remained then? What you will do with the written statement? Simply you are going to corroborate the statement or stand up for defendant number 1, nothing more than that. You can cite as a witness. Can be cited as a witness. What more?
But even if there is a
With Lordship's permission, there is a decision that this is a procedural law. So the
no, sir. Kallas versus Nanku as law of the Justice Satyabrat Sinha, then Salim Bar Association judgment. Then now subsequently there is a departure. That means Kallas versus Nanku also says that it is not that every time the court by a mere drop of the hat will extend the time and accept the written statement. It says that only in an extraordinary and exceptional circumstances the court may extend the time beyond the period of 90 days or so. I do not know whether the Odisha amendment has enlarged any period.
There is the same period.
It's the same 30 days extendable till 90
up to 90.
What more? What more, sir? And the ground which you have assigned cannot come under the extraordinary circumstances.
The ground was taken by the defendant number 2. That is the due to want of some document could not file the retention.
What? The want of document. You do not know. You have executed a deed and what more document? And you are corroborating. Yes, I have executed. The deed is under challenge.
Deed is on.
Sorry, the deed is also not under challenge. The only thing is that since being it is a joint property, I am the co-sharer. Therefore, as a class 1 co-sharer, I am entitled to. That's the only thing.
No, my lord, if your lordships kindly see the plaint, my lord, prayer-ing person of the plaint, my lord. That is reconvey.
On under section 22.
Under section 20.
No. A suit instituted by the plaintiff asserting the preferential right
Item 17. Sorry. 17.
For the opposite party. Who is for the petitioner, sir? Alap Kumar Mahabatra. Alap Kumar Mahabatra.
Not presented. Do you know him, sir?
No.
Can you inform?
No.
So I'm keeping this next Friday. I'm not dismissing for the first day I'm sitting.
No, my lord. No.
So just
Okay.
inform him that this matter would be listed on the next Friday.
My lord.
Item 18.
Yes.
Item number 18.
You are appearing. Who is for the petitioner? Huh? Who is Vijay Kumar? Do you know him, sir? Can you inform? So we can fix this matter on next Friday. Okay.
I've had an accident.
Friday week.
Right.
Item 19.
In the meantime, please inform him. Just record that, please. In the meantime, the advocate in the court of the petitioner shall serve a notice upon the advocate. Please inform that, give a notice that this matter has been directed to be listed on that. That's why. Please. Not petitioner, opposite number.
Item number 19.
Yes. Brahmananda Tripathi. Anybody knows? I will inform. Please inform next Friday.
Item 20.
Discuss. I am appearing for the petitioner.
Who are you in the trial court?
I am the
defendant.
Plaintiffs in the court.
Plaintiff in the suit.
Yes.
What is the
suit was filed for demarcation and
partition suit?
Demarcation of the land of the petition.
It's a boundary dispute.
Boundary dispute. That was along with the petition relief for injunction.
Where is the impugned order?
Impugned order is annexure 4 at page 30.
What is the CMA?
Suit was filed for two reliefs.
No.
For demarcation. CMA, that petition was filed.
Civil miscellaneous application.
Under section 152 of the Code of
So only the ministerial or arithmetical, these errors are no hovering inquiry is required.
No. I may draw your kind attention to page number 13.
What has happened?
Suit decreed.
Yes.
Relief was sought for demarcation of the boundary and for permanent injunction.
Correct.
And to that relief, issues were also framed.
And suit decreed, then why issue framed? Suit decreed only after the issues were framed.
Issues were framed.
And the parties laid an evidence.
Issues were answered in favor of the petitioner.
No difficulty.
Plenty. And one of the issue was issue number 4.
Correct.
Whether the plaintiffs are entitled to get an order for permanent injunction against the defendant to restrain them from entering upon the suit land. That issue was answered in page 16 of the judgment.
Yes.
Page 16 of the brief. Honorable Court hold that under the present circumstances, the defendants are liable to be injuncted from entering upon the suit land. But that relief, which was observed by the court below, that was not reflected in the ordering portion of the judgment. Ordering portion of the judgment I am reading, that is at page 18 of the brief.
What?
The suit of the plaintiff B and same is decreed on contest against the defendant number 4A and ex parte against other defendants. But there is no order as to cost. But the parties are directed to demarcate the boundary line of the suit plot as mentioned in the plaint amicably within the period of 3 months from this order, failing which any parties may approach this court to make it demarcated by the court, civil court commissioner by affixing mark thereon. And the parties are left to bear their own cost. This is the order. But regarding the adjudication regarding permanent injunction, that has been not reflected in the ordering portion of the judgment. So petition was filed under 152 of the CPC to amend the judgment to incorporate that observation. That has been rejected.
No, there was an earlier application which was dismissed by the court.
No.
Anybody appearing for the other side?
Mr. Vidyadhar Pradhan and associates were appearing, but in last year Vidyadhar Pradhan, Mr. Advocate, has expired. But their other associates are with him.
I do not know who has filed the Hogalat number.
Advocate Vidyadhar Pradhan and associates.
So, can you inform any of
Yes,
that?
I will inform his associates.
I got your point.
Yes.
But their presence is necessary.
I will inform them.
Next Friday, I am keeping this one.
Yes.
Next Friday. And he will inform the learned advocate appearing for the judicial notice. Next. Okay. He is the last matter. Call it. No. This was the last matter. Okay. Yes.
Supplemental list arbitration matter. Item number 1, ARBP 15 of 2025.
Sir, I am from VC Mail. This is an application for appointment of arbitrator. Notice has gone, my lord. They have appeared. They have took time the last occasion. There is the arbitration clause is there, page 20.
Now the very I think learned DSG asked for a time.
DSC is appearing in this case. The Satyasindhu Kashyap, the special counsel, might appear in this case.
Where is he? He's not coming. Not even he is not even a virtual mode. What to do? Should we proceed ex parte or what? Bring it in the next week.
Right.
Next Friday, you just inform.
Item number 2.
My lord, I am seeking Lord's permission to appear online, my lord.
Yes.
My lord, the agreement, my lord, would find on page number 19, Lord, 3.57 as to how to resolve the dispute. 3.57.
From where the
Yes.
My lord, pay 3.57. My lord, the three-tier system, my lord, has to how to, my lord, before invoking arbitration, how to go, my lord.
There is an arbitration agreement.
My lord, clause 3.57, my lord.
Page 19, your lordship.
My lord, 19, my lord, 19. The settlement of disputes.
Yes.
If any dispute or difference arises in connection with or arising out of contract, the grievance will be first intended to engineer, who will give his decision in 30 days. If the engineer fails to give decision, then dissatisfied with the decision, he will make an appeal.
These are the mechanism pre the invocation of the
My lord, and all were complied with, my lord.
All has been complied.
My lord, my lord.
Now, what do you say?
My lord, I have to
Don't ask for a opposition or counter affidavits for the sake of counter affidavit.
No, my lord, not at all. Only to take instruction, my lord.
What instruction you will take? All the litigation should be done by the arbiter. Anyhow, take instruction in the next week. First matter, keep it.
Man.
Next.
Deeply obliged. Deeply obliged.
Deeply obliged, Lord.
Item 3.
To take instruction.
This is a fresh admission matter, my lord. Here the agreement is page 25. Arbitration agreement is at page 25.
Yes.
And the notice requesting appointment arbitrator under Annexure 5, that is page 41. No, as 49, page Annexure 6, page 40.
Where is the arbitration settlement?
Well, that is page 25, my lord, clause 25. That's page 25, clause 25.
Service after 2 weeks.
Item number 4. My lord, in item number 3, my lord. My lord, I may be pardoned, my lord. Item number 3, my lord. My lord, Union of India is present, my lord. Appearance may be noted.
So notice we have nobody appears. So what can be done?
Well, here Union of India, I am representing Union of India.
But he was arguing on in item number 3.
Item 3, my lord. In item number 3.
Oh, what we took just now?
Yes, ma'am. That is
Item number 3.
Yes, my lord. In item number 3, Union of India is also party, my lord.
Okay. Service upon 345. 234. Notice on 234.
My lord, in item number 1 also, my lord. 1 and 3.
One is adjourned.
One is adjourned. Next.
Item number 4. Yes, my lord. Adjourned. It may be adjourned, my lord.
Full name be recorded.
Yes. My lord, Mr. S.S.
Item number 4.
May I please, your lordship?
Yes.
Lordship, here the petitioner invoking this jurisdiction for arbitration and conciliation and to appoint the arbitrator, your lordship.
Item number
4.
For your lordship. The arbitration clause is on
What is that?
page number 17, your lordship.
17.
Clause 2.10, your lordship. In the event of any dispute.
Where is the invocation of section 21?
Lordship, that is page number 29, your lordship. The notice was issued on 4th of October 2017, your lordship.
There is a proof of service.
Lordship, I have only annexed the postal requisites only, your lordship.
Service.
Item 5.
May I please, Your Lordship?
Same.
That's it. The arbitration clause in page number 20, Your Lordship.
20.
20, Your Lordship. 13F. Arbitration in the event of any dispute or difference of opinion between the parties, Your Lordship. Yes, Your Lordship, 20. Clause number 13F.
There is a seal, that's why. Yes.
Under notice 21, under annexure 2, page number 26, Your Lordship. Grateful, Your
Item number 6.
No, 1 week time may be granted to comply last order in order to make sufficiency of notice upon opposite party number 2. I needed to file a
Substituted service you have not taken out.
my lord. It was very difficult on our part to get the notice of the
Adjourn for 2 weeks.
Item number 7.
May I please, Your Lordship? I'm from the Eastern Mandal. On last occasion, notice was issued and for the notice was issued to the opposite party. Copy requisites are already filed to my lord.
What is the report?
Requisites not filed, office.
Requisites not filed.
Requisites today, my lord, filed.
Today?
Today, my lord, filed.
The petitioner submits that the requisites for effecting the service upon the parties has been put.
Item number 8.
Item number 8, my lord. Notices were issued to the opposite party.
Anybody appearing? Yes. Anybody appearing?
Yes, my lord.
Huh?
Let's solve this.
Yes, returned. You have not received any information?
No, my lord.
What is the dispute? Agreement for sale?
Agreement for sale, my lord.
Where is the clause?
Page 13, my lord. Last part. It was further agreed that any dispute between the parties arising out
of section 21 notice.
21 notice. Annex of 4, my lord.
Page
20, my lord.
Arbitration consideration.
Annexure 5 page 22, my lord. And reply is at Annexure 6 page 26.
This is the application under section 11 with number 6 of the Arbitration and Conciliation Act.
unless the document is duly stamped.
Duly stamped.
If it is not, then it has to be impounded, then it can be received. We can't act upon. That's the distinction between section 33 and 35. 33 does not contain that word or expression acted upon, but 35 contains the word acted upon, which is now SMT has said that you can't. Now uniform, lot of judgments. SMT, Garware, what not. Subhas, Propale or what? Pofale. Then NN Glover. Go there, sir. Sorry. Though the service has been affected upon the opposite party, and despite the service, Friday. Difficult, sir. Difficult.
Item 9.
Lords, this is your lordship substituted arbitrator to be appointed. Your lordship, a notice of submission was also given. Your lordship, my lords, this is a case that during pendency of the arbitration, this arbitrator passed away.
Or passed away.
Yes, passed away. So I filed an application. I filed a request.
He's on the other side.
He's on the way, virtual mode.
I'm for the opposite party.
Yes.
Lordship, here, may I take you to the short notes supplied by the petitioner? In para number 3, they have stated.
So I will apply with a fresh mind.
Your Lordship, over here, I am objecting to this 11.6 application as because they want to appoint an arbitrator for this arbitration. But as your Lordship, I had cited that both the arbitrators had expanded between.
I consider it, sir.
In fact, they cannot have any objection.
Oh, I just forgot. I just wanted so that I can go through those short notes of an argument before the matter is called on, so that we can have a
discussion.
Discussion and we can finish off. Don't worry.
My notes is there.
You have not.
Lordship, grant me 2 days. 2 days, your Lordship. By Monday, I will file my short note. Sure.
File by Monday. You file it.
But yes, your Lordship.
Matter on the next Friday.
Yes. Then he's serve a copy on Monday.
Yes.
I'll serve the copy on.
Item 10.
Nobody. 11.
Item number 10.
Sorry. Minutes after the petition minutes.
Petition.
10. Minutes. Item 10 minutes.
Yes.
Minutes. The dispute arises between the parties on execution of a memorandum of understanding and a subsequent adherence agreement, wherein the
subsequent
adherence agreement, deed of adherence. Yes, my lords. Now, the dispute arises. The issue arises around the scenario where the respondent was supposed to hand over the premises on which the petition was supposed to start a multiplex. There was a timeline, my lords. Pursuant to the execution of agreement, certain payments were made to secure the interest on the agreement, and my lords, the respondents were supposed to hand over the premises for further functioning. Timelines were lapsed. Handing over was not done. That is why, my lord, the cause of action arose, and we invoked the termination notice. My lords, will kindly turn into annexure 2 minutes. Annexure 2 minutes. At page 37 minutes. The prequel to Annexure 2 lies in Annexure 1, my lords, at page 16, at page 17, where the initial inception of the entire project took shape. That's page 17, Annexure 1.
Which one should I go first?
My lords, it's a prelude to Annexure 2, my lords. Annexure 1, my lords, page 17. The relevant portion starts at, my lords, page 18.
Yes.
My lords, the second part is a petition before this honorable court. PVR Limited, my lords. Now, my lords, at recital 1, my lords, the owner represents and warrants that it has got unfettered absolute rights to construct, develop, propose an integrated retail cum shopping mall on so-and-so area, my lords. And, my lords, at clause 2, the said mall has a area of approximately 1.5 lakh square feet dedicated towards hypermarket, multiplex, departmental stores. Clause 3, the owner represents and warrants that it has got the absolute rights to develop the said mall, including the multiplex space, and has exclusive right to operate, manage, lease, license, or make use of any manner.
No, whatever. That's a declaration about their title to a.
Yes. And my lords, by virtue of this Annexure 1, my lords, the petitioner came into the picture to develop a multiplex to be constructed by the first party of this MOU, my lords. Subsequent to this, my lords,
where is the arbitration clause?
Right away, yes. Right away, answering my lord's question, arbitration clause is at page 23, my lords. It's one more aspect to substantiate my lord's question, my lords. If I may, my lords.
Yes.
My lords, after what my lords sought under Annexure 1, my lords, Annexure 2 was executed, which is subsequent to and to be read along with Annexure 1, my lords. Start page 37. It also contains an arbitration clause. And, my lords, page 39 would be relevant for this case, my lords.
Yes.
My lords, annex clause E at page 39, my lords.
Yes.
If I may, my lords. As a result of the execution of the said lease deed in favor of Grand Bazaar, the present respondent, and Grand Bazaar undertaking to develop the proposed mall over the said land as per terms of stated sublease of PVR, the petitioner, my lords, as stipulated in the MOU, stand attorned to Grand Bazaar, who is the present respondent, my lords, and PVR is the petitioner, my lords. It is agreed that in terms and conditions of the sublease deed, PVR is required to pay the sublease rent.
No, I could not get it. That is just a multiplex space stands attorned to Grand Bazaar means?
My lords, the facts goes this way. In under Annexure 1, my lords, one Bijay Sahu and petitioner got into an agreement, my lords. Thereafter, my lords, Annexure 2 came into being, where current respondent came into the picture.
Somebody is also roped in.
Who is the present respondent, my lords? In Annexure 2, my lords, the present respondent came into being for the first time. Then as a code developer, yes. Lease area stood in the name of first party of Annexure 1. In Annexure 2, my lords, the present respondent as a code developer came into being. The role of the petitioner is to take the project, take the building after it's developed, to develop into a multiplex. That is the entire scope of both the agreements. And now, my lords, the dispute arose when after the respondent coming into being, by virtue of Annexure 2, certain amount in terms of the agreement were paid by the petitioner as a security to secure the interest of the entire agreements, and that when the project will be developed by the respondent within a stipulated period of time as per the agreement, the petitioner would take the possession. Now, the dispute arose when that timeline was skipped. Despite the agreements and the petitioner making the payment, the respondent failed to provide the space for the petitioner to develop the multiplex. That is where the dispute arose, my lords. 2 years, my lords.
So they have not kept the deadline, which is agreed
This is the case of the petitioner, my lords. They have not kept the deadline.
So what do you want?
My lords, now because we have paid 24 lakhs as the first installment was the security, my lords, there's a dispute clause. We have invoked the dispute clause, my lords. Both MOU contains a arbitration clause, the adherence agreement, which is a part of MOU also.
But I appeal for the respondent who subsequently comes into the picture. Now, lords, this memorandum of understanding was executed between the original lessee, as the land belongs to the state. So there was a lease executed in favor of Vijay Kumar, who is the original lessee. He executes a memorandum of understanding with the petitioner. Subsequently, Milas, there was a sublease executed between the owner, as in the original lessee, and Grand Bazaar, who is a developer. And all that atonement clauses were inserted. Now, lords, there is a dispute as it appears, definitely. And so far as the existence of the arbitration clause,
accepted the money.
That is what we dispute. Now,
you did not accept the money.
So what we say is, it was supposed to be received, but the original lessee who received the amount has not transferred it. We also filed the bank statement.
No. Whether that amount was paid to you or to original lessee.
To original lessee.
So now you are a sub-lessee.
Sub-lessee.
Correct. If the original lessee has already agreed to lease out a particular portion of duly or to be constructed particular property, and thereafter he did not personally or himself proceed and make the constructions, rather entered into an agreement with you as a co-developer to develop those properties, then you cannot define what is the obligation of your principal.
But I'm not sure to define, my lords. What I humbly submit.
The only thing is that the dispute has come. Now you are a part of the adherence agreement.
Yes.
Where your original lessee is also a part of it.
Yes.
And if any kind of a dispute that has cropped up, the dispute has to be adjudicated by the arbitrator. Can a Section 11 court at this stage decide a dispute? The
Absolutely
dispute
not.
must be alive.
Absolutely.
Whether it is your responsibility or a responsibility of the original lessee.
That's right.
That's the arbitrator will decide from the agreement.
Yes.
He is concerned with his money. From which he will be happy.
But
you made the original lessee a party here?
Yes, that is my only grievance.
Have you made?
In this application, no, my lords, I have not.
Then how can?
No, my lords, so primary.
How can? Payment was made to him according to his.
Yes,
how can you? He is also a part of this particular adherence agreement.
Yes, my lords.
Why? How can you segregate your reliefs?
No, my lords. I bowed down, my lords, only on
that preliminary objection it should fail.
No, my lords,
only have not invoked a section to him against it.
No, my lords, in fact, 21 has been invoked to him, but in 11.6, my lords, only the present respondent is the party.
21 was given both.
Yes, my lords. At page 76, my lords.
Then apply whatever. Then take decision what to do.
No, my lords, so only as a defense to my lords query, my lords, the only submission that I would beg to make is that, my lords, pursuant to Annexure 2, when everything stood attuned to the present respondent filling shoes of the original lessee, the present respondent making a commitment to have the money refunded. My humble submission is in Annexure 4, my lords.
Where it is said that this money it's his liability from the agreement.
If I can take to that relevant clause.
Please show us from the adherence clause.
Yes, my lords. Yes, my lords.
This money will be deemed to have been paid to him.
Yes, my lords. My lords may kindly come to page 40, my lords.
Yes, please.
Page 40, my lords.
Correct, sir.
My lords. Subclause Roman 4, my lords. Roman 4. May I read, my lords? Yes. The amount part of IFRST paid by PVR amounting to 23.4 lakhs under the MOU has been transferred to Grand Bazaar, present respondent, the receipt of which is hereby acknowledged by Grand Bazaar. Annexure 4 is, my lords, a document supporting this clause. Annexure 4 is a document by the respondent that they have the amount.
Then there is no difficulty.
No, but my humble submission would
Sorry,
be,
then you can't take up. You take up plea there.
that's what my humble submission is, my lord.
Has this when this has come, now it is transferred, the receipt is also acknowledged.
And there is no receipt, my lords. There is no receipt.
You go.
That was the difficulty here is only one humble submission, my lords. But the notice was issued to all of them. And now
they chose, they will suffer. Take that plea.
Because that is what, my lords. What my humble submission will be, there will be quietness to the issue.
Record this. The safest course should have been against both. Now he wanted to choose, whether he chose to chase you, let him face.
No, but I have written him a letter also.
Whatever.
Because I'll facilitate, there's no issue. But the difficulty is if he is not made a party, my lords, then tomorrow when the arbitration fails, multiplicity. That is the difficulty.
What multiplicity?
Because the money is with him. There's no receipt attached to the agreement.
Acknowledgement is there. You have to explain that what is the meaning of this.
But I have already explained it in the letter written to them. What I wrote in my letter is that I will facilitate the refund. I never said I'll refund.
He has chosen a risk. That's all. We will rely on this clause and will do it. He has chosen a risk. He has to prove.
Well, your lordship will kindly appreciate tomorrow if he gets added as a party in the arbitration proceeding, he will then question the party authority.
Appreciate the jurisdiction and the scope.
Absolutely,
of interference at section 11 stage.
Well, sir, bow down to that.
That's all. Can we go into the nitty-gritty of the defense? Can we go into perceiving something what may happen and what may not happen? We will simply go by that. There is a validity of the agreement. Parties have entered into, and there is a live dispute. That's all. It's the arbitrator who will decide.
But your lordship will then keep the aspect of impletion.
We will not say anything. We will not say anything.
Plus, the reason being, he issues a notice to all of us, and then he chooses to only implead the.
No, nothing. The defense which should have That's why I do not want any retard just to.
My lord, absolutely justified.
I beg pardon, my lord. I'm sorry. My lord, item number